is being carried out by the order which has been procured by suppressing the material facts that I had an injunction, order of injunction by the Civil Court Junior Division Bidhannagar. By suppressing the fact, the promoters went to the upper court before the senior division and suppressing all the material facts had an order of injunction, and by showing that order of injunction, they are continuing with the construction work over the suit property.
Why you did not place those matters before the higher forum? You must have placed those facts before the higher forum.
Senior division, I have come against the order of the senior division.
No. Before the senior division, you might have placed those facts that this order of injunction is operative.
Yes, my lord, I had made an application under Order 39, Rule 4. That has not been heard. Even date being fixed, on the first day, they said that we will file opposition. On the second day, they came that my senior is not there, but they are continuing with the construction work.
Let it appear on Monday. Monday to diye dao.
Much already.
May I be permitted to mention item number 312, 312. Lordship, only for direction for service upon the respondents, Lordship.
To be mentioned. To be mentioned Monday.
My lord, may I be permitted to mention a matter of court number 1, which has been shifted to my lord.
Sir, this is not a bench for courtroom number 1.
My lord, no,
we are sitting at 1. Please look at the notification. We are sitting with Justice Bhattacharjee at 1 for mentioning.
Thank you.
Lordship, this matter I am for the petitioner. Lordship,
to be
this
mentioned?
matter has usually assigned before your lordship.
Why?
Lordship, there is two lordship single bench judgment regarding the lordship the power of the municipal magistrate for passing the order of demolition. Now the honorable single judge has assigned this matter before your lordships, and
Single bench has assigned the matter.
the honorable chief justice assigned the matter on the basis of reference of the order passed by the honorable justice.
This is really a special bench to consider.
Yes.
When both of you are ready, tell us.
Lords, I am led by my learned senior.
Don't dear, when you are appearing, that's all.
Mr.
Tell us. Whatever. That's why I am asking a time. Both of you, please tell me the date when both of you are ready. We can fix the matter. Is a assigned a special bench matter, so we'll take up.
Lots of my humble submission is from my clients that now the Rojas going on.
I do not know, sir. When you are mentioning this matter, we are asking both of you to suggest a date when both of you can argue. Tell us the date. As simple as it. Tell us the date, both of you.
Let's say after 2 weeks, Lords.
Give me a date. Hey, calendar to diye dao.
Let's say 12th April, let's say Thursday.
12th is somewhat dicey for me. Anytime after that.
No, 15th. No,
No difficulty. 15th. On the prayers of both the parties, both the councils, let this matter be fixed on 15th as per order.
Sir, proceed. For the petition.
First, appear for the petitioner.
Is a fixed matter.
Not
There is, last time there was no appearance.
so all of a sudden matter appeared. Lordship. We have missed the list. Lordship. It's unfortunate for us.
No, WPC2. Where is the other side? Union of India?
Perhaps Mr. Budit Cherat is appearing for the respondent Union of Indian Lordship.
Where is he? What is the matter about?
Matter is Lordship. Petitioner was a dark Sevak Lordship. He was appointed in the year of 2008 Lordship. Thereafter Lordship, disciplinary proceeding was initiated against him Lordship. Inquiry was done Lordship. After that Lordship, disciplinary authority passed an order for removal from service without any future disqualification from the employment Lordship. Thereafter Lordship preferred an appeal. Against that appeal Lordship, appeal authority told that the order of the disciplinary authority is same order Lordship. And thereafter Lordship, I preferred an original applications before the Lordship entire administrative tribunal, and then passed that order Lordship by rejecting my application, and I preferred a judgment Lordship before that Lordship during the course of the inquiry proceeding, and as well as the reply to the charge sheet, I have admitted that due to some mistake on the part of myself, which is unintentional, that wrong was done Lordship. And on the
What
basis
was that wrong?
Lordship, that some money order and SBI accounts in the post office Lordship, though I have mentioned and recorded the credit in the passbook of the depositors, but I have not credited to the governments due to my mother illness, and I admitted in that position Lordship, that due to my mental disturbance, I have not credited that.
How long you did not credit?
But within Lordship 90 days Lordship, and on
You credited.
credited Lordship, thereafter credited. There is no loss at all Lordship.
Did you credit it prior or subsequent to the charge?
Prior to charge sheet.
Prior to the
Prior to
charge
charge
memo being served on?
Because immediately when it is detected, then it has suspended my client Lordship, and thereafter no charge
After
sheet was
suspension.
After suspension.
after.
And it is recurrent or an isolated incident?
No Lordship, it is all of a sudden it is good, but there is no isolated Lordship.
It is only one incident.
Only one incident Lordship.
Where is the charge memo?
Lordship, charge sheet is page 68 Lordship.
No, it is not an isolated incident. More than one.
More than one.
And Lordship. And
So it's a recurring feature.
within the short span of time Lordship, that was
Whatever, sir, you are dealing with the public money, and then you are expecting that you should be given. These are really in a nature of a mercy petition.
Lordship.
How you justify your conduct? How
Only
you justify your conduct?
only thing Lordship, I have replied to
It is
the judge.
immaterial whether it is a 20,000 rupees or it's a 2,000 rupees.
Yes, Lordship, if there's there
Even a single
Sure.
penny will create, because you are holding a very responsible and very high positions, and there is a lot of trust in you.
Lordship.
And then 90 days. And that too after the suspension order is passed.
So what is the infirmity? What is the procedural infirmity in the inquiry?
Only thing is that Lordship, though they only have admitted that by way of it is unintentional on the part of Lordship petitioner Lordship, and that was on the basis of that Lordship inquiry was conducted Lordship.
Saying that he was Yes. Anything you want to cite?
Not
Any
only
judgment?
Lordship Rup Singh judgment wherever I have relied before the landed tribunal Lordship.
Rup Singh Negi.
Lordship versus PNB Lordship.
Then
Yeah.
what has been said there?
In the said the Lordship, there is a confessions before the police authority Lordship on this basis of
That's not a confession before the police authority, sir. This is a caution.
in this fact of the case Lordship.
That is a different,
That's
because we are concerned about a statement under section 161 of the CRPC. We know
Lordship.
how far it is reliable. We are conscious.
Only thing Lordship in
But this is how our disciplinary proceeding decided on a preponderance of probability. Is not the beyond any reasonable doubt. That's not a concept. So you have written consciously. There was no pressure. You were writing when there was nobody who could put a pressure on you.
no Lordship, that's not been.
Then if that being, then how can you rely upon this Negi's judgment?
Only Lordship, my admissions should be proved, but on the basis of
Act was totally different. There they were only relying upon the police documents during the course of investigation. Which
So-
were yes to face the court.
So how you justify? You have appropriated the money, sir. It is not that you have just kept it in your almirah and forget because of the treatment of your mother. You page 61, you have said that I have utilized the money and I did not have a money so that and therefore I cannot deposit. You arrange money subsequently. The intention is very laudable, that you had no intention to remit the money to the government's exchequer. You have appropriated it. If you have, then what to do, sir? Sympathy, mercy, empathy has no role in the dispensation under the law. What can be done? You yourself has admitted. Nothing. Hey, दिए दो. Hey, साहब का चमक. You should उसके बाद ये काफी तो और एक पर्सन किया ऑनरेबल subsequently said that we don't know what is the concept of honorable.
I'm for the applicant. My lord, I'm led by Mr. Banerjee, Jitendra Banerjee.
What is this, sir?
My lord, there was a direction for submitting the decree. Actually, decree was not there. Decree was not drawn up. My lord, I have obtained the copy of the decree. On 19th, the decree was drawn up. My lord, may I submit it? My lord, and the next thing is
Shocking to us. That's what that is to be to be done. We therefore direct this district judge Judea to seek an explanation from this request. Dismissed on contest. So, and thereafter, no one has stated that they would prefer an appeal. What you are saying? Everyone wrote question. Could have done it immediately thereafter. Which support to the department staff. Here also, all by the department. Is a job of a I don't know.
So we have collected the decree post the order of your lordships. On 19th, probably we have. No, no, no. Would it be lordship sign sanction to allow us to stitch it and my lord? My lord, I am the defendant. Suit for declaration of title instituted against me, my lord. My lord, both the courts, my lord, judgment of affirmance. Now, my case before your lordship is that, my lord, the predecessor in interest of the plaintiffs had not produced any document of title, my lord, despite, my lord, they are bound to do so, and the court solely relying on the arrest record of rights have decreed this.
No, no. You have, you said that you have title in the property from your vendor.
I tell your lordship, the original owner, my lord, there were 4 sons. 3 sons have transferred, it is their case that the 3 sons have transferred the entire property. Our
To them,
yes, to them.
but there were 4 sons.
There were 4 sons.
Look at, see the junior,
Now,
what he's saying.
thereafter, my lord, these 3 sons have transferred the property. I claim ownership to that 1 son.
Okay.
Now, their case before the London trial court was that there was an amicable partition. And that amicable partition is reflected in the arrest record of rights. And there was an exchange, there was relinquishment of share.
There must be a document of relinquishment.
Yes, that is my
There,
case.
there must be something.
Yes, that is my case with your lordship. Now, the trial court took the arrest record of rights to be a sacrosanct, and relying on section 14 of the West Bengal Land Reforms Act, the court has come to a finding that
That recognizes only 2 kind of a partition,
yeah,
or a transfer.
but my case with your lordship, it is a deed of, there has to be a deed of exchange, and there has to be a, if it is a relinquishment, then there has to be a transfer. It comes under the.
They are not denying that there is another brother.
Yes, that is an admitted case.
Admitted. Only they purchased from 3 of the brothers.
Yes.
Case is that the other brother has relinquished.
Yes.
And then there is no deed of a relinquishment.
No deed of relinquishment.
Only the record of right was corrected.
Yes.
And on the basis of the record of right,
yeah,
they have said that the 3rd, 4th brother has no right, title, and interest.
Because the record of rights recognizes that earlier relinquishment and exchange. That is there.
How the court has arrived at the finding?
Your lordship would kindly takes the stay application, my lord, that, my lord, from the trial court's judgment, my lord will find.
Just 1 minute. Which portion?
Kindly takes page 42 of the application and
42 of
this the application.
first application is section 5 done.
No, my lord, section 5, my lord, due to bona fide inadvertence, we have filed,
No,
but
no,
we will
then
not be
section
pressing.
5 has to be.
No, we will not be pressing section 5 because there is no delay. Will not be
Let
pressing.
us see our staff reporters.
But I am told that there is no delay.
Yes.
There is no delay, buddy. There is no delay. Now your lordship would kindly take
40
42.
can 2.
42.
Can 2.
Can,
Yes. In reply.
yes. The learned advocate for the plaintiff stated that from the exhibit 2 and 3 certified copies of the RS record, it will become clear and that an amicable partition took place amongst the brothers of Gopal Ghosh, in view of which Gopal Ghosh relinquished his share in the suit property in exchange of other property. And defendants have no right to challenge the said RS record when they remain silent for so long without raising any objection against the said records. Since 1961 till 2012, when the name of deceased Gopal Ghosh was recorded in LR record of rights, LR records, there was been no objection from the side of the defendants, and as such, the plaintiff
Unless he claims an ouster. No, no,
Yeah.
that is a submission, sir.
That's
This
a
is a submission.
he
Tell us
pointed-
the finding.
No.
Tell us the finding.
kindly takes the next page. Now section 14 of the West Bengal Land Reforms Act, my lord has found,
Yes.
was amended in the year 2002 with retrospective effect from 7th August 1969. By virtue of such amendment, partition can only be affected either by registered deed of partition or by decree of a civil court. No other mechanism for partition is recognized under section 14 of the Act. However, in the present suit, having regard to the facts that the factum of oral partition was mentioned in the RS record of oral
There is
partition.
where the RS recorder right does not indicate oral partition.
No, there the record of rights says that there has been an amicable partition. That is there. That is there.
Yeah.
As such, section 14 of the Act as amended in the year 2002 cannot nullify the effect of oral partition if it is found that joint property belonging to the co-sharers were in fact partitioned amicably prior to the 7th of August.
What property was given to him? Your vendor. If there is a oral partition, there must be some other properties.
Yes, there must be some other properties.
Then
We
that
are
has been
denying that there was any exchange at all.
no. What about the oral partition? By virtue of oral partition, if there is something which has been done, then what properties you got?
My lord, our case before your lordship, there has been no exchange and there has been no oral partition at all. We are all along in possession of that property.
What about, because one thing they have to prove it,
Yes.
that suppose if there are 4 properties left by your
In
predecessor.
the record, my lord, it does not transpire that they could not.
Now, if by virtue of an oral partition, the parties have decided that property A will go to these brothers, property B will go to these brothers, and on the basis thereof, the parties have really altered the position and the record of rights are accordingly amended.
Yes.
Whether there was any record of right in relation to other properties where you have been shown as an exclusive owner.
No, rather, my
What I am asking.
yes, my lord. No, rather, my lord. Post this, my lord, the record of rights has already been corrected in favor of my predecessor. The
Oh.
LR record of rights also was corrected. That was also my case before the landed trial court. And it in the four corners of the evidence or in the judgment, there is no reflection that some other properties have also been
This is what
retrieved.
really I wanted to know. When they
The
talk
court
about
wonders
the
whether
oral
there-
partition, that is what I am thinking.
Yes, yes, no. But that is also not in the record. But the substantial question of law,
Uh,
my lord, ground two, my lord, in my
This is what you can't. You can read other works. You can. What is it? Upload.
As it is at admission stage, I can't have any locus standi to adjust my lord. But we are the caveator. If your lordship passes any order on the stay application, so I thought, my lord, sorry, my lord, to that effect. Until and unless it is admitted, I got no locus standi.
No, yes. But on yes. My I was prepared and signed. File contains a report of the district judge. Yeah. Very important from the considered bench block was also formed. It appears from the explanation offered by the not be brought up. And because of the occupation for the delegation. And thereafter, the matter was the matter, and thereafter the matter went out of the mind unless an application is placed for drawing up the
as indicated above, the judgment and the judgment was delivered by the additional district judge on 22nd September 2023 in Tatilapi number 4 of 2019. Subsequently, the court reopened after the long puja vacation in the month of October and November, when the court reopened. Our court 23 November, in the mid or don't you have a calendar of recent calendar? In the middle, my lord, mid November. Reopened in the middle of the month of November 2023. As offered is accepted, that there was a heavy work pressure prior to the puja vacation. We do not find any justification in the said explanation that after reopening of the court, a considerable period of more than 3.5 months, nearly more than 4 months elapsed. Furthermore, every court in the country is grappling with the menace of the heap of cases mounting day by day. But that does not exonerate a person in discharging his solemn official duties. Drawing up of the decree is also an important and integral part of the duty entrusted upon the said officer. And we are unable to comprehend such explanation that because of the work load, he could not drop the degree within the time, drop the degree within the reasonable period of time, within reasonable time. Without bidding adieu to the issue, we direct the district judge to take up the matter himself and may proceed further in the administrative side. Right? Grappling in the contractually heap of cases mounting day by day in docket of the courts of the country. According to the merit of the case, after reading the advocate for the appellate, we found that the instant appeal was a substantial portion of law. On a ground two, my lord, in my respectful submission. What about ground two, my lord? D'accord. One, whether both the courts below were justified in holding that the RS record of rights finally published is sacrosanct and divestition of right title and interest on the strength of an oral partition is statutory proved. Next, whether both the courts below were justified in holding that the entry in the record of the RS record of rights to the effect that the same is amended and or altered on an amicable / oral partition in absence of any other corroborative evidence in this regard. These are the 2 points you'll have to, nothing more than that. Now, what is the application? Only a question. Oh, where is it? The adverse position. Not here. That is a submission which was made.
Page 44, my lord.
No, finding on an adverse position.
Adverse position, that was the submission, and page 44 is
No, that I have already said. That is
and
what.
adverse position, there is no finding of
No.
finding. Your lordship, the
Sorry.
can one is not pressed. Can one?
The counsel for the appellants submits that that can 1 of 2023 was filed inadvertently, perceiving the delay having caused in filing the instant second appeal. But the stamp reporter indicated that there is no delay in filing the instant appeal, and therefore he praised for not pressing the said application. In view of the above, the can 1 of 2023 is not pressed. What about?
My lord, can 2, my lord. Is
You
not
wanted to secure his presence. What do you want?
a stay of.
This is
My lord,
absolutely not. Leave is granted to file a supplementary affidavit within a week from date. Let the application be listed before the appropriate bench.
lordship, may I speak to you?
Yes, ওটা দিয়ে দাও ডিগ্রিটা মেমোর সঙ্গে স্টিচ করে দেব দুটো কপিতে ফটোকপি ওটো yes.
My lord, this is the appeal, my lord. Mr. Soor is now appearing for the state, my lord. Also,
I'm appearing. I am appearing for the state.
So what?
my lord, a date may be fixed, my lord.
Why argue?
My lord, Mr. Mukherjee.
Last time because of him you could not
Yes,
continue.
my lord, we need to de novo restart.
What? Oh,
Madam-
he has come.
Madam.
Then come after 15.
My lord.
When? Come ready. We have raised several issues. Your junior was there.
And for the defect, it's for the defect.
He was there. He will tell you what point has been raised. You have to answer.
My lord, 16th or 18th?
16th is
Tuesday, 18th is Thursday.
18th.
Can it be at 2 p.m.?
Why 2 p.m.? From the morning. We don't. Because in this appeal, they read all the evidence. So we do not want that there should be any disruption, continuance. They will not finish it up. Don't worry.
Molada থাকবে তো।
And you have a very limited role. You don't have. That's let them.
Lordship, in item number 7, Mr. Devabrata Roy is appearing on behalf of the appellant.
Compliance report, madam. Let us see.
Lordship, I am not briefed in this, ma'am.
It is only for the purpose of compliance. Let us see. এই রেকর্ডটা এসছে রেকর্ড এসছে কেন this has it been received by the Registrar General in his office, inner office? Which the procedure which is a contradiction. We said that they got to be the court is sitting before the next date of listing. 18 March. Report says that it was communicated on by email also on 8. 7th को इसने लिख दिया 8 को email किया था और स्पेशल मैसेंजर से 11 और 12 को ये तो the record has not come. Whether it has reached in the department, we are keeping it. Ask the Registrar General or in the department whether it has arrived. देखिए ना, जिस को ना 2 PM रखो.
अच्छा, ठीक।
Yes. Not a dutiful person. Hey, Lakoto, none appears in 8. Let this matter be listed under the aiding order 41. Now, let this matter go out of list. Next 9.
Malad, 9 for item 9, Malad, I am appearing for the appellant, Malad.
Yes.
I mean, led by Mr. Ranjan Bachawat, Malad. I'm praying for.
But this was mentioned that they wanted some urgency, and now they are not coming. None appears in support of the appeal. Let this matter
Malad, I'm appearing for the
let this
appellant,
matter
Malad.
go out of list.
Malad, I'm appearing for the appellant,
Yes,
Malad.
next.
Malad, item 9, I'm appearing for the appellant, Malad.
Hey, somebody was on virtual mode. Hey. Somebody was, yes. Who you are appearing for whom?
Malad, I'm appearing for the appellant, Malad. Item 9, I'm appearing for the appellant.
Sound? Please unmute.
Malad, am I audible, Malad?
Sorry, your system is muted probably.
Malad,
Unplug your headphone, that may help.
You unplug your headphone.
Malad, I've unplugged my headphones, Malad. Am I audible,
No,
Malad?
it is still connected with your laptop or unplug it.
No, Malad, it is not, Malad.
Yes.
Sir.
No, please unplug it from the system itself, not from your ears. Unplug from the system.
Malad, it is unplugged, Malad. There is no headphone, Malad.
Then you are not audible, sir. We can't hear you.
Lordship will kindly pass over, Malad.
Sorry, we can't hear you, sir. Our system is perfect. Your system is not working.
Malad, am I audible, Malad?
You are I do not know. Can you show by symbol that in which matter you are appearing?
Malad, item 9. Malad, item 9.
Please, by symbol, your fingers, tell me.
Item 9, Malad. Item 9, Malad.
Just keeping it at 2 PM. If you can come to the court at 2 PM, please come. Not out of list. Come at 2 PM.
I appear for the last occasion, my lord.
Which one? 11.
Item 11. Matter was fixed twice, lord. On 20th, 21st December, my lord fixed it. They appeared. Some of the respondents they appeared and matter was adjourned on their behalf. On the last occasion, my lord,
Yes.
lord, it was a
You are the appellant, sir.
appellant.
So don't blame the other side. Argue.
Lord, my application under the application under order 39 rule 4 by the defendant respondent allowed. And that is the Lord,
So what suppression you have done?
Lord, no allegation that there is any false averment, false and material suppression.
So,
No
so
averment,
why the court
no
has vacated?
finding also. The learned court has gone into the merit of the injunction application, dealt with the merits and
Yes.
vacated the interim order. And without fixing a date for the application for injunction also. The next date fixed was for Order 711 application, hearing of order 711 took up the matter. No, still now it is pending. Order 39 rule 1 and 2. We'll later discuss.
Where is the application on order 39 rule 4?
At page 62, my lord. At page
Page-
62 of the application. Allegation of suppression or anything. Only on merit. my lord.
Where is the order of ex parte ad interim order of injunction?
At page 40, my lord. The-
40.
Of this application. Order number 2, dated 14th February.
What are the materials which were placed in order 39 rule 4?
My lord,
What are the materials which are placed in order 39 rule 4?
nothing, my lord. Apart from the repetition, nothing, they have not. Apart from this petition, or at page 62, my lord.
For the other side.
Other side, my lord, Mr. Parthopatim Roy is appearing on behalf of the transferee. No, one of the
What
transferee.
about, this is a application by defendant number 3, 4, 5, these transferees. 2, 3, 4, 5.
4, 5, my lord, they are transferred.
2 is your stepmother.
2 is my stepmother, 3 and 4 are my stepsisters.
And what about 5? Is a transferee.
Transferring. But Mr. Rai is appearing. He appeared in the last matter was adjourned on, and Mr. Sukumar Bhattacharya sitting in court number 2.
Where is he? Where are they?
The last occasion they appeared.
Then we are.
May I inform them again? But in the meantime, my lord,
That there has been a cross separation of material.
injunction application is still pending.
Just
Matter is fixed in the peremptory hearing board.
satisfied in such right. Okay, application for a party has so misleading a statement. Also misleading a statement. And the injunction was granted without giving notice to consent. The court shall vacate the injunction unless for the reasons it considers it not necessary to be so there must be a cross suppression, taking a false statement or a misleading statement. Second is that the order of action is a party. That is, we are not concerned because it has been given a party. Notice. But this is the only problem. There is a false and misleading statement. Now, that only one misleading statement. Because so this can be said to be a statement. Schedule B for part of schedule A. Schedule A is a block. It's 23 look up. Schedule A. Schedule C is a block, which is the subject matter of the deed of gift. Is plot number 2161. Oh, correct. But schedule A. I didn't sugar. Plot number 08. Restraint from evicting the prisoner from dock number 930. Well, 930 is a schedule C. A may be never. So, wait a minute, right? 931 is also a part of the schedule. B and C is a part of schedule. So the plot number 2161. 2161. 2161. So he has segregated it. Here say 930. Injunction is on this plot number 930 and 931. And 30 and 931 is a C. So plot number 208. 208 is not a subject matter of
He is appearing for the, well, let's go. Mr. Patracted Roy is appearing for the caveated respondent number 5. It's on legs in courtroom number.
argue. You are competent enough to argue. How can you support Order 39 Rule 4? You know the scope of Order 39 Rule 4. Have you seen? It simply says that if he has made some false or misleading statement, then and then only you can sustain this order. On merit, you can't. That has to be decided under Order 31 Rule 1 and 2. Order 39 Rule 1 and 2.
There must be material suppression.
Two things. That's why I say the suppression of the material fact, making a false or misleading statement. Tell us what they have suppressed. They have not suppressed. They have challenged the deed of gift. They disclosed it in their plaint. The deed of gift in favor of the defendant number 2, your predecessor. And the defendant number 2 has admittedly sold the portion of the property or some portion to you, claiming as an exclusive owner on the basis of the deed of gift. That was disclosed in the plaint. Can you say the suppression of the material fact? You can't say it was because they have challenged the deed of gift. One of the reliefs claimed in the plaint is, apart from partition, that these two deed of gift, which is executed in your favor, means your predecessor, is bad, void. So they must disclose the deed of gift. They have disclosed. Where is the suppression? Where is the suppression? I do not find that suppression.
One-day accommodation.
No, this is not a way. He has gone into the merit. How? The co-sharers. This is a question where it can be segregated. If one of the reliefs of the partition cannot be granted, at least the primary relief of declaring the deed of gift to be void, can it not be granted?
That is after trial, also subject to correction.
True. So where is Order 39 Rule 4? Where? How? Under what? Where you have stated that they have suppressed? They have made a false and misleading statement. Where? In the order 39 rule 4, I did not find anything. Where is that?
Ready with this brief today, my lord. I'm not ready with.
Sorry,
Can-
brief
Excuse
today.
lordship.
I have a strongest of reservation in this regard. Receiving a brief before night, receiving today. Why you have accepted?
Hello, Mr. Bhattacharya Rai is appearing.
Sorry.
Yes.
You are not in the matter. You are not in the matter. Tell us. He does not sign Wakalatnama, I believe.
I have not signed.
Then who is the who has signed the Wakalatnama?
Sarbananda Shah.
Where is he?
My lord, he is in courtroom number 10.
Sorry, then we can't. We will proceed. Who is appearing for the other defendant?
No, it's appearing for the one. My own sister is supporting.
What about 2, 3?
2, 3,
And
Mr.
four?
Bhattacharya, Sukumar Bhattacharya appeared once, my lord. And
Where is he?
adjourned.
Tell everybody to come at 12:15. We are simply granting this much. Otherwise, we will not.
12:15, my lord.
12:15.
50.
12:15. 20 minutes.
Fine.
And tell Mr. Bhattacharya, Sukumar Bhattacharya also.
Right.
Well, my lord, I am appearing for the appellant, my lord, in this matter, my lord. Mr. Johar Datta is appearing for the, my lord, state respondent, my lord, and the private respondent has not entered appearance, my lord, in spite of service, my lord. Now, my lord, part of the relief has already been, my lord, granted, my lord. The RTA has already issued the no objection certificate to fly my bus up to, my lord, Krishnanagar. But, my lord, there is only one difficulty. The union leader is obstructing the bus, my lord. And, my lord, a
Then what
hearing
we'll
was
do
called.
it? Then what for the writ was filed?
My lord, the writ was filed on twofold.
Yes.
To grant the NOC so that I can proceed up to Krishnanagar, extension of permit, my lord.
Correct.
And in the meantime, my lord, the union leader was stopping the bus from picking up passengers at the Navadvip bus stand, my lord.
Correct.
He is continuing in this act, my lord. He is not appearing in the matter, my lord.
What you prayed for? In
My
the
lord, I
writ?
prayed for extension, for grant of the NOC, my lord.
That has been
That
done.
has been done, my lord. And now, my lord, my bus should be protected, my lord. Every day he is disturbing, my lord.
Sir, can the appellate court can go into? That's why I'm asking. What is the reliefs you claimed in the writ?
In the writ, my lord, I claim twofold.
That is what you have said. Only one fold. What is the other? Please unfold the other.
Yes, my lord. The other part is, my lord, that a direction be issued to the district magistrate, Nadia, to look after the matter. He called for a hearing, my lord. But even in the hearing, that person did
Everything
not
has
appear.
been granted in your favor. Then
No,
what
my lord,
for the
regarding
relief?
this matter, stopping of the bus, my lord. I filed a
Was that
supplement.
a relief? One of the reliefs claimed in the writ petition. I am asking you. You are not answering it.
May I, my lord, give the copy of the writ petition, my lord?
Please read
Yes, my lord.
the reliefs.
Sorry, my lord. A writ of or in the nature of mandamus do issue, commanding the respondent such and such to explain the basis of their inertia in not issuing the NOC to the petitioners.
That has been granted.
Yes, that has
Now
been
NOC
granted.
has been granted. Then
And or not proceeding against the private respondent number 10, who is obstructing the bus of the petitioners from entering inside the Navadvip bus stand to
who
pick
is
up
the
passengers.
private respondent?
He is the union leader, my lord, of the bus stand, my lord. He is putting Badli workers on the bus, my lord. I cannot take my own staff, my lord. I have to put his staff on the bus, my lord. When the bus was earning 2,000, now it is earning only 1,500 every day, my lord. I am suffering huge losses, my lord. But this is the system.
Was running 2,000, you are suffering 1,500. I could not understand.
My lord, he has started a system that every, my lord, the operator has to put his person's choice of his staff on the bus, Badli workers. The conductor and the helper has to be from the union leader, my lord. I cannot engage my staff, and I have to hand a part of the money collected every day to him, my lord. And then he will pay me my subscription, whatever I get, my daily earnings, my lord. This is a system that is going on. Not only me, there are a lot of buses plying there, my lord.
Have you stated in your writ petition that what he is doing?
Yes.
What you are saying?
Yes.
Have you stated in your writ petition?
Yes, my lord, I have stated, my lord.
Where? Show us read the paragraph.
Paragraph number 7, my lord.
What you have stated.
That the petitioner state that the private respondent, who is a union leader of Intak at Navadvip bus stand, is taking undue advantage of the fact of non-issue of the NOC by the respondent number 7 for extension of permit of the petitioners up to Krishnanagar, and is demanding a lump sum amount of rupees 2,000 per day from the petitioners in order to allow the bus to enter Navadip bus stand and or to pick up passengers from the vicinity of the Navadip bus stand. And the petitioners are suffering a loss of 1,500 per day by plying the bus as the Badli conductor, who is an agent of the private respondent number 10, dishonestly appropriating money from the daily
You
sale.
have engaged him.
My lord,
You have taken that Badli worker.
my lord, we are forced to, my lord. Otherwise, he will stop the bus. We won't be able to ply the buses, my lord. Not only me, my lord. Kindly call for a report, my lord. All the bus operators are suffering the same fate. He is exercising statutory powers and colorable power, my lord, in that area, my lord. He is the end all and be all. That person, my lord. Kindly, my lord, call for a report, my lord. All the bus staff, all the operators will, my lord.
Why will go into that?
My lord.
Who is for the other side?
Mr. Johar Datta is appearing, my lord.
Where is he?
My lord, I have got a valid permit. I am paying all taxes. I cannot
I
buy.
understand, sir.
My lord, I will get him, my
we
lord.
appreciate your agony, your anguish.
My lord,
No difficulty, sir. We appreciate it.
my lord.
But the Constitution says that the court must decide the matter in front of the other side
Yes,
also.
yes, that is
He
there.
has a constitutional right to be
My
heard.
lord, on the last date also he did not appear. I will inform him, my lord.
Have you lodged any FIR?
Yes, yes. In the supplementary affidavit, I have annexed everything, my lord. And a meeting was called.
FIR has been lodged against respondent number
Yes,
10.
yes, private respondent, my lord.
What is that?
It's in the
And
supplementary
you
affidavit.
served the respondent number 10.
Yes, my lord.
Who is appearing for him?
Nobody appeared for him, my lord. One junior advocate, he phoned me up. He told me that he was briefed to appear in the matter, but he was not paid the material instruction, my lord. He did not appear. A very junior member. I gave him twice, my lord. I gave him opportunity to appear, my lord, before the matter was admitted, my lord. I will serve him again if your lordship so desires, my lord.
Where is the FIR?
My lord, I have filed one supplementary affidavit, my lord. In that, everything is there.
Please inform the judge, Mr. Dr. George.
And my lord, in the alternative, may I file a supplementary affidavit to bring this on record, the letter they have issued, my lord, regarding grant of NOC. Let the matter be taken up Monday, my lord. Today only, my lord. I will get him, my lord,
Mr. Doctor,
at 1,
immediately to appear, not at 1,
within 10 minutes,
within 15 minutes.
my lord.
Let them come.
Yes, my lord.
Uh,
This matter, my learned friend, my lord, engaged me, my lord, but subsequently they have taken no objection. No more appearance. Subhendu Banerjee. Subhendu Bandyopadhyay along engaged me, my lord, and they have taken no objection.
For the respondent number 2,
Respondent number, he is appearing for the respondent number 2 to 4 and Mr. Rai is appearing for respondent number 5. The vacating application was made jointly by 2 to 5.
that I have seen. I have seen. Cannot be done. He has taken a brief, then somebody must be. We can't wait that way. When he has taken back,
2 months.
then we can't.
As your lordship.
What do you have to say? You support the order coming within the purview of order 59. I have seen your application. Tell me what is the ingredient of order 39 or needed there.
So far, my lord, the concept of misleading or statement.
Then how?
Only one thing, my lord, I am certain. Whether the undue hardship and other things can be
Can't be. This can't be a ground. Undue hardship will only come when it was passed in your presence.
Yes. Here, my lord.
Not passed in your presence.
Therefore, I
First proviso does not apply to you.
the judgment, so far the order I can take if it is expertise.
But you have not pleaded a single word of undue hardship.
No
Not
findings
pleaded
also.
a single word of undue hardship.
If it is the expert,
First thing is, does not apply to you, first proviso. Second is, you have not pleaded anywhere undue hardship. I have gone through the entire order 39 group.
if it is expertise so far me is concerned, my lord, I have two options. I will prefer to appeal against the order of injunction
Or you can go and
file along with documents and ask for hearing of this thing. So order 324, my lord, taken that.
sorry,
You
it
got
can't be taken up in this fashion.
can you
He
consider
has not said anywhere that there was a material.
this subject?
He has said everything regarding the deed object. He has told about the sale deed having been executed.
Yes, so paragraph 6 onwards, there is all
Secondly, this is a composite suit. Suit for
Declaration.
declaration and partition.
partition
Even
into
if the
declaration, my lord.
Even if the partition cannot be granted, I can understand because there is some other problem. But the first primary relief of deed,
Then, my lord,
you are the party.
yes.
So
Subsequently, that is why, my lord, if the preliminary degree, what is the degree sought for, my lord? The partition and injunction.
no,
And for cancellation of the,
correct. So
it is void ab initio.
cancellation is defendant number 2. From whom you have
Yes,
decided
my title is based upon the.
you are the best person, you are the necessary party, you have been elected as the
Yes,
party.
yes. It's not
So where is the
now, my lord, can you consider what the injunction sought for?
not to disturb the position?
Was there for a moment and my lord, can you consider?
What document you have shown about your?
I am on the plaint itself.
No,
I am on the plaint.
first from the plate.
Yes.
First,
Page 23.
page 23.
Yes, my lord. The schedule.
Forget about the schedule.
My lord, my lord, can you consider injunction has been sought for.
Which one is the page 23?
In application for injunction, my lord,
Where is the application?
that is scan 1 of 2023, my lord will find.
Can one, I do not find.
Second file. Item 11.
The Jalpinder Singh, somebody else has said.
Probably, my lord.
This is a page 23, sir.
No, let us solve different matter.
I see.
Oh. This is 11.
Yes, my lord. And your lordship, please fix that. Once my lord read the entire order, it is the
Which page you are saying?
No, you are talking about the schedule. We have seen that. That
that is
B and C is a part of A.
A.
No doubt.
No, what is A? My lord, can you consider what is A?
Please, I have seen.
Whether, my lord, I put this question myself, whether the injunction.
No, the question is, they have said, it's not a suppression. They have said that these are the part of the property which was owned by the donor. And out of this, properties, B and C have been given in gift,
Yes.
by gift. Now they say they have challenged the deed of gift.
And subsequent.
Question is that what was the injunction which was granted?
Yes.
And on that basis, they have said that since the position appears to have been admitted, I mean approved,
No, so subject to question was the
then
position.
the injunction was that not to evict the plaintiff from the without the process of
The lordship can consider the
now
findings.
you said that you are in position. In support thereof, you have not disclosed any document in order that rule for. Tell us. I have seen that. Tell us
For the
that you
findings
have
is
produced
concerned,
the
my lord,
document.
if your lordship can answer, what is the findings and the what is the basis on which the position of the plaintiff has been admitted? My lord,
On
What-
the basis of a affidavit given by him, you, no, she is a sister. Anyhow, is the one gentleman, Jasminder Singh, has saying that he has issued. The court has recorded, rightly, wrongly, whether that can be a good finding.
On the bed.
Scenario.
that is
Now,
on.
question is, you said that you are in good. They say they are in good. Then only it will come that either it is a separation of some material. Second thing is false and misleading statement that has been done. I can understand. Tell us that why it will come under the suppression. Where is the false and misleading statement?
If your lordship can stand, if it is an ex parte order injunction has been granted against me, I have three courses open for me. One, I have to challenge that order appeal, or I can file an application challenging the order ex parte order injunction by filing 34. I can take all the grounds. Jitas Pandey subject to question, my lord.
What?
Jitas Pandey's
This Pandey's judgment says that an appeal when filed against an ex parte agency order of injunction, then in that event, it is only to have to accept whatever has been
mentioned in the plaint.
as sacrosanct and then say that the injunction cannot be granted.
Granted.
You have not chosen that.
So other
Not chosen that.
options is
Then
are there.
39 rule 4, it should be within that particular ambit.
Subject matter.
Please, I have read.
No,
that.
no. What is point, my lordship?
Here the-
No.
No.
Yeah, say.
Please read. Order 39 rule 4.
Order 39 rule
Let
4.
us understand what it says. So busy,
No.
many phone calls are coming, what can be done? Please read that.
ছুটি দিনে এসছি
See? Any order for injunction may be discharged or varied or set aside by the court on application made thereto by any party dissatisfied with such order. So it can be varied, discharged or set aside. First provided that if an application for temporary injunction or in any affidavit supporting such a party has knowingly made a false or misleading statement in relation to the particular fact, and the injunction was granted without giving notice to the opposite party, the court shall vacate the injunction unless for the reasons to be recorded it considers that it is not necessary so to do in the interest of justice. So what is required is knowingly making a false or misleading statement. Now, first proviso, second proviso comes. Provided further, where an order of injunction has been passed after giving a party an opportunity of being heard. This is not a case. You were not given an opportunity.
Yes.
The order shall not be discharged, varied or set aside on an application of that party, except where such a discharge, variation or setting aside has been necessitated by a change in circumstances or unless the court is satisfied that the order has passed. So this second proviso does not apply because the ex parte and interim order of injunction was passed. First proviso. But suppression we have said is a inbuilt, ingrained into making a false or misleading statement. It's not there actually. But we have accepted it. Now tell me.
The subject to question, my lord, being an order past expertise, my lord, I have request to file an order certain rule 4. But very along with and taking all the points.
The is Pandey, I believe in 1976 ILR. And subsequently, there is another
Bhagavad my lord,
which says that 3 courses of to me probably according to
so
apart from answering the show cause under order
I file an objection to the same and
the 39 rule 4, then this or an appeal under order 43 or is review also.
Four. But there it written 3 courses, my lord. That's what it is.
So I say according to the
And there, my lord, the expertise order.
no difficulty.
It comes under.
Order that rule 4.
It shows either of the evidence. Then you have to work within that bracket of that. Order 39 rule 4 that is very clear. Show us.
My lord, if you lordship can give me one place, I can totally. So far, my understanding is to some extent, my lord, though that in the order that rule 4, an expertise order of injunction passed against the party can take all the grounds irrespective apart from the grounds mentioned under order 13 rule 4.
What ground? Like a contest one? No. No. Then what about the order 39 rule 4 has been made? A separate provision.
Just carve out the
Take away because the court will not permit anybody to get the blessings of the court in the form of an ex parte and injunction by making a false or misleading statement of suppression. But real.
But
Where is that?
that amendment is so what that amendment my lord is asking for. It is whether my lord the person is doing expertise order is
only one judgment. I have not come across a single judgment as
I'll try, allow me one day's time. One day's time, my lord.
Nothing.
Actually,
Nothing. It's
I'll come.
It's only for the purpose of gaining a time.
I'll come back on Monday, my lord. In the first morning, if there is not, it is not there. I'll come and say there is not there. Otherwise, I'll place before your lordship.
Nothing.
If that be so, my lord, I'll try my level best. If I find nothing is there, my lord, I'll come back in the morning and I'll submit before your lordship. That much faith, my lord, can get for my lord. I'll come back and say there is nothing. But if I find something, my lord, because still I am under belief, my lord, I'll take that objection. Apart from the grounds as mentioned, 39.4.
Then in that case, the court always decide order 39.
Rule 4 allow with this.
Together. Are we not suggesting, are we not directing that these 2 applications will be decided as a
in isolation of the original application?
No, in one go. That both.
That to have been the.
It has not been done. If you say there is a question of order 39 rule 4, then you satisfy that the ingredients of order 39 rule 4 is there. We are ready to accept. Show us.
That's why, my lord.
I do not find anything from your application at least.
What is followed from lordship? I bow down to that. So far, it does not come.
Second. Yes. Correct.
One day record, only one day, in the morning.
Think about Bengal club. You are having that. That is on a different.
That is on different footing. Documents which subsequently it comes. Their provisions are there. I'm not on Bengal club. I'm not on the Bengal club. I'll not rely on Bengal club.
Not on Mukta Kisi as well.
This still holds the field. Muktakeshi,
A part of it has gone by virtue of this.
Bengal club, my lord, Muktakeshi, so far if a logically, my lord has got number of times these two judgments, my lord can, the Muktakeshi has not been, to some extent, diluted, it can be said.
Again saying, to some extent,
Yes.
it is, to some extent, it
The
is.
documentary evidence.
The question is that whether the coordinate beach can dilute it.
That is something. But so far that provision, whether the expertise identity order injunction, what are the recourses open? Only one day.
I said.
I am taking only a day's accommodation.
If you take recourse to either of one, then
Malad can pass.
fine within that.
Malad can pass any order. Malad can allow the appeal. Well, I am paying only one day to cite for your lordship. It is for my satisfaction. Malad can consider if I felt
you have been appearing in this matter for a pretty long time. This matter has not been taken up for the first time.
No,
so you got more than a month's opportunity to go into it. If you do not prepare yourself, that's the.
It's my fault.
I can say.
It's my fault.
Really.
It's my fault. But so far, Malad can pass the order, any order. Malad only Monday at the morning. I should come before lordship. Only that portion.
Not.
I Joshua boy. Joshua boy. Basis. Yes.
Got it?
Basis. The judgment of the
It is the reference of the judgment.
2000 volume 2 ICC page 312. May I read out? Yes, my lord. It was reported in Calcutta CHN also, my lord.
What is by which court?
Justice Bhattacharya. Judgment please, please.
By which court?
That is also 2000 volume 2 CHN page 856. My lord, a single bench, Honorable Justice Bhaskar Bhattacharya.
What? What is the first title?
Jitesh Pandey. I'm relying on Jitesh.
Jitesh Pandey is a.
My lord, only one.
I do not know because I was aware of Jitesh Pandey somewhere in ILR.
My lord, I am reading only one paragraph. Paragraph 11.
By Justice Bhaskar Bhattacharya.
Yes.
What it says, Jitesh Pandey. Three courses are open.
After hearing the learned counsels for the parties, and after going through the order impugned herein, I find that the learned first appellate court below, while setting aside an ad interim order of status quo passed by the learned trial judge, has concluded that the plaintiff did not apply for the temporary injunction in good faith, and arriving at such a conclusion along with the application of for stay filed by before the appellate court. The learned first appellate court was quite conscious that the learned judge has no occasion to consider those documents as it appears from the page I could run of the order impugned, but in spite of such observation, by relying upon those documents, interfered lack of bona fide on the part of the petitioner in making application for temporary injunction. Thus, after vacating the order of status quo, the learned appellate court will send the record back to the learned trial judge for disposal of the application for temporary injunction. In my view, a person agreed by an ad interim order of temporary injunction has threefold remedies. Firstly, he can answer the so-called notice by filing written objection to application for temporary injunction, putting forward his defense, and thus convince the court that the plaintiff is not entitled to the injunction and that the order of ad interim injunction should be vacated. Secondly, such person can come forward with an application under Ordinance Rule 4 of the court immediate variation of the ad interim order of injunction, thereby not only drawing attention of the court to fraud or suppression on the part of the plaintiff in obtaining the ad interim order of injunction, but also exposing his own defense to the prayer of temporary ad interim order of injunction. Lastly, without taking recourse to the aforesaid 2 ways, vacating the ad interim order of injunction, the aggrieved person may state a prepare an appeal. So I am on the second.
What it says, then again, that word misleading, I think.
Apart from that one,
it is a misreading of the judgment. Not misleading, it's a misreading of the judgment. What the judge single bench has said, that under Order 39 Rule 4, he has to come before the court and get vacation of the interim order, and he can also put his defense to it. The question would be what should be the consideration for the court when an application under Order 39 is taken up? I don't think so that the single bench has said anything beyond that. You are not debarred from putting your defense. You can.
So I am on the basis of this. Relying along with.
Cannot.
With the appellate court or for this. But also exposing his own defense to the prayer of temporary or ad interim order.
No, he can. But only thing is, when the court considers it, then whether the court will consider those on merit or the court will confine within Order 39 or letting both the applications are really taken up together. No difficult. The court can keep this Order 39 or as an objection or
the first course.
And then there is no better on the part of the court. Decided. Who says? But once only application under Order 39, then what for this provision is made in this statute? One has to give effect.
I am on the impression that 39(4) along with দুই তিন চার চলে এসছে।
I am sorry.
So far, my understanding was that, my lord, on basis of which I make my submission.
Then we don't accept.
So but that alternative rule 4 and also espouse his own defense if it is for expedited order of injunction. এই জন্য বলতে নেই।
That's why I did not what this
My lords, Manvasa Devi landing.
Manvasa Devi is there.
Manvasa Devi, my lord, I am conscious about the judgment delivered by your lordship Manvasa Devi. And to that extent, my lord has went by to some extent diluting the provision of Inri Gautam Kumar Hada. That yes, if it is fraud is apparent, then court has the power.
That if such which cannot be the step.
Yes, sir.
Then also
The appellate court has the jurisdiction.
the court can.
That's I'm conscious. So what this
Just consider an extreme case that in the suit claiming that the Howrah Bridge
Yes, yes.
there and the court has granted
calls us shockingly calls us to the court.
if the appeal is there, everybody will get it. Permit immediately stay.
Yes, sir.
That's an extreme case. But not in this way. Sorry, we can't.
Then, my lord, that was my other thing. But it is wrong, my lord.
We don't accept.
But 2, 3 and 4.
My lord, may I have it?
My junior, my junior just now phoned me. He had a conference, but my junior, but now he is in Aramla. My junior, he has got the. Who is your junior? Vishnupada Singh Ora. But that is why he phoned me. He said, my father is ill, that is I could not come. I could not go. So that's why 2, 3 and 4. 2, 3 and 4.
Marketing application
Just phone me.
আমি বলেছিলাম করে দেবো বাংলা
Just phone me.
থাকতে পারবে না সোমবার সকালে আমাদের
Thereafter, my lord, he told me, sir, I said, oh, now since his father is ill, that is the one suffering from heart disease. He could not
argue. You are arguing.
I know it. I know it. That PP is not. I shall argue it. I shall argue. Your office is known. You are not taking it over there. But I am not. But I can give at 2 p.m. Sir, I shall come back. Just now, our PP is not with me. That is the problem. The problem is another thing also. It's just when a corporate thereafter. He did not come. You also can understand my situation. You also had a that student face when you're lost in the bar also. Only that person. Sir, you will appear. I will be. Your loss is no. Morning, you also face that problem. That is problem we are facing nowadays.
Then you should also.
I know, only I shall come back at 2. I shall come at 2. Whatever that submission, I can make my submission. Just now, that is why I'm coming. Yes.
No, the joint application by Mr. Rice clan and Mr. Harish clan is sufficiently represented.
Real
Yes, that's why. Now they are representing by 2 different parties.
Your application reveals any kind of a required in order. That's
Yes.
your question of law.
Yes,
It's not what.
Yes.
Whether you have a good case, you have a bad case, whatever you are doing. That will be decided by the court.
At 2 months.
Right. Yeah.
But item number 12, my learned senior friend is here. দাদা আপনি এদিকে চলে আসুন।
Yes, yes, my lord, I'm extremely sorry. This is your lordship, my lord. My lord, I haven't the brief with me, my lord. On the next Friday or Saturday. Friday, I'll do it, my lord. Your lordship kindly fix it, my lord. This is the first time I'm appearing before your lordship. My lord. I haven't the beer also have something else. No. I saw it in the monthly list, my lord. Thereafter, I didn't see it.
This means there is an indication that it will be taken up.
My, then on Tuesday, my lord, Tuesday, please, my lord. I beg to be apologized. Nothing, my lord, I'll just get the final instructions, my lord. Final instructions.
There is a serious allegation which is made against the.
Yes, my lord, it was made later on, madam. Yes, madam.
The state.
I am appealing for the state, yes, madam. That's why, madam.
You are also representing the superintendent of police.
Yes, madam, obviously, obviously.
Raising
Objection, yes, madam.
despite the no objection having granted.
Yeah, they're doing these things of that.
Obstructing.
Obstructing, yes, private respondent is obstructing, madam. My lord, everything I'll come to.
Tell your officer to submit a.
Yes, my lord, your lordship kindly pass an order.
I have given a copy of the supplementary.
Yes,
affidavit.
madam.
Everything is there, madam. I have served it. Agro Dishin order.
Supplementary affidavit?
Yes, my lord, it is there on record.
We have been taking the main earnings claim in the writ petition, which appears to be complicated in nature. Sense that not only the advance was flood, on the transport of the issue and mortgage, but the advance was against the crowd response. Was creating an obstacle and our disturbances, smooth line of the vehicle and compelling the appellant to his men and associates. The instant appeal is filed against a portion of the order which is declined by the trial, the latter portion, which is declined by the trial, with it, by the second. Affidavit, supplementary affidavit filed in connection with the instant appeal reveals
Dated 6th of
complaint having laws.
dated 6th of November 2023.
Complaint having laws with the concerned police station that despite the no objection certificate having issued by the competent authority in terms of the order of privacy, the said private authority still backing upon in creating an obstruction and or disturbances in picking up the commuters / passengers at a particular destination, and also putting a pressure each associates. It appears that despite such complaint having laws with the station, no steps have been taken. Mr. Doctor, the learned advocate of the state, showed his inability to apprise the court as to the steps taken in this regard in absence of any further instruction. Such view of the matter. Now we find that the superintendent of police Nokia is arraigned as a party respondent in the instant writ petition as well as the mandamus appeal. We therefore direct the said respondent to file a report to this court disclosing the steps taken on the basis of the complaint so laws before the next date of this. Let this matter with this stage on 17th April. Under the same area.
Much obliged, man.
It's called
Grateful.
I've seen those many. None appears in support of the plea. They appeal to dismiss what is what. Next.
I am appealing for that. A suit for declaration. Declaration, my lord. I am plaintiff lost both the court on the ground of the bone of contention between the parties regarding the death of the father. According to me, my lord, my father died on 25th of September 1954, and according to the defendant, 15th of December 1958.
Now, what documents will
produce? That both the sides produce different death certificate issued by my lord. Lordship will kindly come to this stay application, my lord. My death certificate is at my lord page 12, my lord. This is issued by register page 12, my lord. Annexure P1.
This is issued by what the date?
Malda, some
Department of Health and Family Affairs.
yes, my lord, Malda. And there, my lord, they are at my lord will find at page. It is a death register, my lord. They have relied upon. That is page 22, 23 months. The thing is this, my lord, and Lordship will also find in the death register they have relied upon. Date of registration is 25th of December. Date registration date is 25th of December. It's also surprising to me, Mala. Comparative study has been made by the learned trial judge in their impugned order, Mala. And registration date has been mentioned on 25th.
How this was
This was true because of the reason my Lordship will kindly come to the impugned order, my lord will find, my lord. Yes, my lord. That is, my lord, page 8, internal page 8 of the judgment and order, my lord, of the impugned of the appeal court. And in the Lordship will find in the running page 55 of the CAN application, second paragraph, my lord, the aforesaid two
this page, internal page.
Internal page 8 of the judgment and running page 55.
It ends appellate court judgment.
Yes, appellate court judgment at page 8, my lord.
No, it ends at 6, page 6.
May I hand up my copy, my lord?
This is the judgment dated 29/1/2021, passed by the additional district judge, first court, Malda.
Yes, my lord.
So it does not contain page 8, internal page 8. The judgment ends at internal page 6.
Well, I'm sorry, my lord. I'm relying upon this trial court, my lord. Yes. Sorry, my lord. Sorry. I'm sorry. There is
internal page 8.
Page 8. the aforesaid two statute provides specific provision for the registration of birth and death at relevant point of time, and it is also observed that two statutes were not given with any prospective effect by registration or by the legislative authority. It has been observed that Exhibit E document has been issued long ago, that is 1st January 1959, whereas the exhibit
How it is material? Suppose father died in 54
Yes.
or died in 58.
Yes.
Then how it makes a
Well,
claim title?
yes, madam. The defendant are the sisters, married sisters of the plaintiff.
Correct.
In view of Lordship's knows in view of the amendment in the Hindu Succession Act, madam.
I know section
Yes, ma'am.
23 has been taken.
Yes.
So
That is,
retrospective.
yes. In that even, my lord, they will claim title on the basis of this.
They have to claim title.
According to me, my lord, death took place in before 1956. Madam.
56. Are you governed by Mitakara?
No, we are Daya Bhaga, very much Daya Bhaga. Yes.
Prior to codification, Dayabaga, the daughter have a right. You can't deny. It is only in Mitakara where you are governed, then only the male. So how can you claim, even if that prior to 1954, 55?
That issues are not placed before the
No,
turn.
this is what is very simple. If you are governed by Dayabaga, then the daughter always had a right. Other than Dayabaga.
The subject.
So you can't, now only embargo was they cannot claim patronage unless the male chooses because of creation of embargo or decision. Now that has been limited by virtue of amendment in 2005 or 15, I don't know. This 23 has been delivered. And newly started or amended provision has come, which says, and there are getting of judgment, which says pending suits will be hit by the court.
And it will be given prospective, retrospective.
Yes, yes. So nothing. Nothing on that ground, sorry. You can't.
Comparison has been made only on the ground of a document which was issued during holiday. Reliability and genuineness of the document of
Which
which the learned court has relied upon. Relied the
Exhibit E.
yes, ma'am.
Exhibit E shows that it was issued in.
Yes, ma'am. It is. Lordship will kindly come to page 22 of this document, my lord. It issued on 25th of December. Lordship will find the registration date.
No, it's not issued. That is the date of
That is the date
registration.
of registration.
Yes, but how it can be, my lord? Date
Can be.
a date took place, my lord, before that. Not date took place on 25th of December. No, I am asking this question to myself, my lord. Reliability and genuineness of this document, I am questioning.
That this department, if it was cited. Yes.
No, neither of the parties. Both the only, my lord, the conclusion.
How this document?
Yes, madam. Yes, madam. That is the reason.
If you did not raise the objection at the time of tendering this document, then can you now say
That I
you have not said, you have not objected? I do not find from the judgment that you objected.
it is not apparent, my lord.
Then sorry, we can't. We can't.
Only me.
And you are bound by it.
Time of receiving, it appears. It cannot be.
The date does not see the holidays.
No, I am not on that. The date not took place in 25th of December.
It can.
I am questioning the registration.
It's all open.
Subject to normally they may differ this.
You have not raised any objection at the time of the agreement.
Yeah, another thing is this one. Normally, Lordship will kindly have a look at this 22 page. Cause of death is also mentioning the
Malaria.
Yes, madam. Or normally death certificate is containing only
This
date
is
of
the
death,
entry in
date
the
of place,
register.
date of time. But cause of death is not.
Your
Normal-
document has come into existence after 41 years of the death.
In the both the cases. I am, they are also, we are also. Genuineness and authenticity of the document. And
I could see page 3 of the judgment.
no, that
Look at it. The last paragraph, he has narrated that what the apprentice has cited which document. And he has said that there are two documents marked after objection. So it does not really say that there was anything like that. And then the page 4 top, exhibit G, without any objection. Nothing is written. We can't believe. Sorry.
and the
Let us come
appeal
back and then dictate. Nothing is.
My lord, may I be permitted to mention an urgent matter, Lordship, before this? My lord, this is appeal, my lord, my appeal. The read petition is disposed, my lord, on 30th November 2023. Meanwhile, they have filed contempt before the lauded single judge, and the rule has already been issued for personal appearance, and the personal appearance is fixed on 12th of April, my lord. And unless my appeal is heard out, my appeal will be infructuous, my lord.
Mention it on Monday.
My lord, I am.
Be permitted to mention a matter which was listed yesterday in item number 9. It is a group 4 matter which was specially fixed yesterday because due to the order was for the single bench is on base of registration cancellation. But the person whose number is cancelled is due for renewal of license under electrical contracts on 31st March. This was on the list yesterday, but as the court was not there, that if the court permits, it can be put to hearing today itself because otherwise 31st March, there is no other dates to be heard. It's a matter of registration cancellation of GST.
It has been cancelled.
Yes, my lord. We had prayed. There was a number of precedents in the single court where the registration was open. There is no due left. Return has been up to date, updated till date. On that specific order, the single bench has put it in the epidemic opposition. There is no merit in the case. It was
When the order was passed by the Hon'ble single judge.
single bench. Not 14/3/24. 14th March.
When have you filed the appeal?
My lord, I have filed the appeal on the next Tuesday.
Who appeared for the authorities? For the
state.
Tandon advocate.
For the
Have you served upon him?
Yes, ma'am.
Yes, have you served upon him
Yes,
before
ma'am.
mentioning?
He is already in court number 1. He said that if the court pleases, he can do the hearing.
Your GST has been cancelled.
Yes, my lord.
For the, for which, for the year?
Yes, my lord, it has been cancelled for not filing of return. We had filed the return, we had submitted, gone for the appeal was rejected on the grounds of limitation. We came for, before the single bench, there was a number of precedents where the single bench reopened the GST number so that we can continue. On that, in this impugned order, the
Two PM, inform Mr. Siddiqui.
yes, sir. Thank you.
Write that down. Give the number, file has to be brought.
bench pass and contempt matter and order. My lord, I mentioned this matter, but file has come. My lord, indeed, maybe
Sit. Sit one day.
I hand over the slip.
Yeah. Application.
No, my lord, the interim order, there is no interim order to put us to.
That means we have to dispose of the appeal.
Yes, my lord. My lord, my petition is very simple to restore my GST number.
Here is the some materials must be there, sir. Some applications, the writ petitions should be there before us. How can you do it like this?
My lord, I had called for the writ petition. It was fixed yesterday. The writ petition should have come.
But you should have taken out some kind of you want an interim order to be passed. Some materials, some documents has to be given. We are not in a position to understand that what writ petition was, whether it was a fit case for passing the interim order. We do not know. Sir, there are two aspects. One is the limitation ground. The main point is the limitation ground. Now, is there any power given upon the authority to condone the delay beyond the?
Normally, my lord, the court.
I am asking.
No, there is not.
Under the act.
No, my lord, there is no. Normally, our courts are allowing this.
Correct. That is what I am.
No, it is not like section 34 of the arbitration.
Correct.
Only thing, my lord, normally, my lord, what I have seen, my lord, I just saw the writ petition. My lord, the cancellation had taken place in 2022. Registration was cancelled. They preferred an appeal. But normally, what is happening is, my lord, for 2 weeks.
These are all technical grounds.
Well, that's why I'm coming. Normally, well, these orders are being passed normally by the honorable single judge. I don't know when why an exception was made out, but normally this order. I tendered apology. Just একই order দিলাম তো সেটা আমাকে দিয়েছিল so my lord 6 months because my lord he has not filed his return for 6 months. So the portal should
you can impose penalty.
Well, that is under or whatever. Well, I'm not coming in the way. I'm saying that my lord, don't record my consent to that extent. I'm not coming in the way.
Now he has already filed the return.
Yes, my lord.
No, my lord, he has not. He could not file because the portal has not opened.
Yes, filed.
My lord, we have filed the return till the date of cancellation. After the portal gets locked, as soon as they open the portal, we will file the return till date.
And with whatever penalty.
Penalty and late fee interest.
What are the penalty which is provided under the act?
My lord, late fee is there,
Late fee.
and there's interest and late fee.
So whatever, my lord, they will calculate it.
Whatever. The portal.
এখানে আছে কোনটা এটা জমা কোনটা দিলাম দিলাম ঠিক আছে।
Return. Yeah, show us.
Well, there are circulars to that. effect, but
My lord, the late
yeah.
fee is calculated by
Late fee is
system as soon as we file
Yeah.
a return
It's
for.
an automated, well, it is a self-declared, well, this act is a self-declared act. Well, the moment he will file it, this will show this is the late payment, this is the delay. These are governed by circulars, different circulars. But I would have brought those circulars, but I didn't know that this matter would be taken up today.
What's the urgency now?
My lord, he's an electrical contractor. There is a vendor list that comes up every 31st March. He has to show the GST registration has been revoked by 31st March. There are no.
He cannot run a business.
He cannot. I
Run a
cannot.
business.
Yes, my lord.
Without, he cannot run a business. Without,
Then what remains in the red petition also? There has to be disposed. We are disposing of.
Yes.
The order dated March 14, 2024, passed by the Learned Single Judge in WPA 4079 of 2024, thereby rejecting the prayer for interim order, is the subject matter of challenge in this intra-court appeal. Paragraph. The learned advocate appearing, this matter was mentioned by the learned advocate for the appellant, citing grave urgency in view of the fact that unless a decision with regard to renewal of registration of GST is taken on or before 31st of March 2024, the appellant will suffer irreparable loss and injury as the license will not be renewed.
My lord, the tender list, there is a list that comes out from the
The
Bidut Bhavan.
list of eligible tenderers.
Yes.
Nah,
Vendors.
the list. The appellant shall be precluded from being enlisted in the list of participating for enlistment in the list of eligible tenderers.
Eligible vendors of the electricity board.
Considering such urgency, this matter was directed to appear in the supplementary list today. The learned advocate for the appellant submits that the registration of the appellant stood cancelled on the ground of non-filing of returns. First up, registration of GST. First up. Registration of GST. First up. The learned single judge directed filing of affidavits by the respective parties, but refused to pass an interim order. First up, considering the fact that the ground for cancellation of GST registration was only on the ground of non-filing of return, this court is of the considered view that the interest of justice would be subserved if the West Bengal GST authority is directed to restore the appellant's registration and open the portal for a limited time period to enable the appellant to pay off all the revenue that is due. Full stop. Including any statutory penalty and interest and or charges. Full stop. In view thereof, this appeal and the writ petition stands disposed of by directing the
First provision.
who is the effective respondent.
My lord, state GST.
First provision, my lord, kindly see.
My lord, effective respondent is respondent number 2.
Respondent by directing the
First provision.
West Bengal GST authority to restore the appellant's registration, appellant's GST registration, and open the portal for a period of 30 days from date to enable the appellant to pay the revenue together with the statutory interest penalty and fee. Interest penalty and late fee in respect of the said return. But only one thing, Mr. Chakravarti, here it says the figure of which has been provided by Mr. Ghosh. Do you have a figure?
For that instruction would be required. My lord, for
Do you full stop?
The automatic cancellation will come with regard.
Mr. Chakravarti, learned advocate appearing for the Mr. Chakravarti, learned advocate appearing for the GST authority submits that the moment the portal is opened and the appellant files the return, the entire amount of revenue, interest, penalty, and late charges that may be late fees that may be leviable shall be automatically reflected in the said portal, in the said system. In case the appellant fails to make the fails to file the return, in case the appellant fails to file the return and pay the revenue, interest, penalty, and late fees within the time limit stipulated including any amount due as tax within the time limit stipulated herein before, this order shall not have any force and the respondent GST authority will be entitled to block the portal again, and the order cancelling the registration shall automatically stand revived. With the above observations and directions, now the appeal and the writ petition stands disposed of with the.
this is rule 23. My lord, registration is governed, cancellation is section 29, revocation is under section 30. This is rule, what I have handed over, my lord, that is the rule, my lord. And the late payment, there are circulars. What would be the delay if there is a gap of 6 months? Or
So we have made it any.
Thing is the figure would vary.
Absolutely, my lord. My lord, we need require some time.
The dates will remain same.
Absolutely.
That's the thing.
My lord, as soon as we submit a return for this month, in the next month, the late fee and the interest for the previous month is automatically adjusted in the liability.
My lord, would remember, if I'm not, my lord had given a judgment in late payment surcharge in electricity matter. The same methodology, the day he gives it, the calculation would be made, there will be difference of, and next month it will be recalculated and you have to pay the money.
My lord, a single leave may be granted for them to communicate this order verbally so that they open it.
Tax, not be a tax. All the parties are directed to act on the server copy of this order.
Just because 31st is the last day.
But I'm not coming in the way. It's not coming in the way. But this type of matters, it's not a adversarial litigation.
So you communicate this.
I'm not doing it. Thank you. I do not want to stop businesses. At least I don't want to.
No, these are all technical issues. There may be some lapse, maybe for various reasons that has been done. I'm really wondering that the appellate authority has no power to condone the delay beyond that.
I think there is a division bench judgment presided over by Justice Boshak on this.
My lord,
extension of the time limit.
I remember in so far as the income tax matters are concerned, under the Income Tax Act also, there was no power which was given to CIT to condone the delay beyond the period. Then there is a judgment of the Gujarat High Court delivered by Justice Shah, Moti Shatilal Shah, who was the Chief Justice of our High Court. He says that the writ jurisdiction can be invoked. There is no difficulty on the part of
Well, can we
and I think that was followed by another division bench judgment of our High Court. Then my single bench judgment was also there.
There are hundreds of cases where the delay has been called.
Section 5 identification to indicate করা যাবে না।
No, it is
I
not.
think there is a judgment of the division bench.
My lord has also delivered a judgment sitting with Honorable Chief Justice. My lord has also delivered. Not worded like arbitration act section.
Yes.
No, I know. Here's what is. We are coming after 5 minutes. Another bench will sit. চিঠিটা তো আছে হ্যাঁ দেখে নাও মঙ্গলবার দিন আচ্ছা ঠিক আছে
ও 14
Yes, madam. Now, I have gone through the findings of the both the court below. So far as my death certificate is concerned, that has been objected by the defendant. But unfortunate thing is this: their death certificate has not been objected.
then what remained
Thing is this: I am before
if you have not objected
Yes.
then the rule of law is that you cannot say that this document is not genuine or no credence should be given. And secondly, even thereafter, if we ignore this, even if we accept 1954 as a date of death, yet you do not say that their daughters cannot claim a partition. Now, after this amendment,
Yes, I have the copy of the.
nothing. So what more is required? Previous. Special provision completed 23 left seven both the main and female is specified class is property right of such partition shall not arise unless the male heirs chose to divide the expectations. Heirs is not entitled for a partition. That has been deleted from 2005. We now insert it.
ঠিক আছে দিচ্ছি দাঁড়ান এখানে আছে স্লিপ আছে আরেকবার দিচ্ছি আচ্ছা করেনি Now the petition is. It is. Yes. Yes. Well, only I'm saying the validity and legality of this death certificate which has been, although I have not objected.
No, that is what the problem is. I think 2001 volume 2 SCC is against you.
2001?
Volume 2 SCC is against you. There is a judgment of the Supreme Court by Justice S.B. Sinha where it has said that if you have not objected at the time of
trial,
the trial in relation to any document, then in that event, before the appellate court, you are precluded from.
Yes, I'm just.
So you can't. Now you are in appeal, you can't take it. You did not object. So in that event, you can't. And secondly, even if it is there, you are admittedly governed by the Daibaga. You can't say that you are not governed by the Daibaga.
And the particular document was not corroborated by any other independent witness to
But you have
substantiate.
not objected it for raising. Then you can't say mode of proof. You can't raise an
Before
objection.
this was fallen from your lordship, the individual witness was also not there.
I was
corroborate.
thinking
Yes.
about it that
Yes.
this authority who maintained the register,
Yes,
he
well,
should
that-
come and prove
Depose.
it. But if you do not object to it and allowed this document to be accepted, then it's an admitted document.
I cannot improve my case.
Admitted
What is
document.
there in
Then
the
what
record?
remains?
I cannot. I cannot improve more than this. Huh?
The seminal point raised by the counsel for the appellant in the instant appeal is that both the courts erred in upholding the date of death of the predecessor of the parties as on 15/12/1958 and disbelieve the certificate of death issued by a concerned authority indicating that the said predecessor died in the year 1954, and therefore the instant appeal involves a substantial question of law. A suit for declaration of title and permanent injunction filed by the plaintiff appellant is to dismiss by the trial court, and such decree is affirmed by the first appellate court. It is a specific case of the plaintiff appellant that the property in question originally belonged to Bhuvan Mondal, who left behind him surviving two sons, namely Thakurdas Mondal and Bhiku Mondal. It is further disclosed in the plaint that the defendant respondents, being the daughters of the said original owner, after their marriage, before the commencement of Hindu law, have no right, title and interest in respect of the said property. The plaint for the proceeds that the defendant respondents claiming their right, title and interest by virtue of a by virtue of inherited, by virtue of law of inheritance, are trying to interfere with the position of the plaintiff appellant, and also attempting to alienate and or transfer the said property in favor of a third party. Some of the defendants respondent entered appearance and disputed the aforesaid contention. The contesting respondents were critical on the date of death of the said Bhuvan Mondal, as disclosed in the plaint, which according to them is 15/12/1958 and not in the year 1954.
25/9/1950.
25?
9.
Dig it off. In the year 1954 is jaga 25/9/1954. The defense is simpliciter on the basis of intestacy, and being the daughters who is recognized within the ambit of Schedule 1, recognized within Class 1 of the schedule appended to Section 8 of the Hindu Succession Act, inherits the property of the father in equal share with the brothers. Both the next paragraph, both the courts invested time on the veracity of the statement of the parties, contesting parties. Taken in relation to the date of death of the said Bhuvan Mondal. It is concurrently held that the said original owner died on 15/12/1958 and not on 25/9/1954 as claimed by the plaintiff's appellant. Both the certificate of death produced by the plaintiff appellant and the defendant respondents are marked exhibits in the suit. It is undeniable that the certificate of death relied upon by the plaintiff appellant was objected to at the time of tendering the same in evidence, whereas the document in support of the death of the said original owner, as claimed by the contesting respondents, were marked exhibit without any objection. Though we find that the aforesaid point is mere academic and should not be projected upfront for the purpose of passing a decree for declaration as sought for, but we feel that it would be apposite to make observations and the law in this regard. The document relied upon by the plaintiff appellant was objected to by the contesting respondents, meaning thereby its mode of proof and the veracity of the contents thereof is required to be decided by the court at a later stage of the proceedings. Any document which is marked exhibit only for the purpose of avoiding the decision to be taken thereupon, the parties can challenge, can raise such objection at the time of final hearing of the suit. And it is an ardent duty of the court to decide such objection at such relevant point of time. Is a judgment of the Supreme Court in 2001, Volume 1, SCC, page 1 of Justice K.T. Thomas. The moment the rival documents are placed before the court and the adversary did not raise any objection in receiving a document in evidence, the rule of evidence postulate that not only the mode of proof, but the authenticity and the veracity of the document has not been challenged, or in other word, accepted by such adversary. There is no fetter on the part of the court to proceed in deciding a matter on an admitted document. And once the court embarked to accept the same as uncorroborated and or unchallenged document, we do not find any illegality in this regard committed by both the courts below. For the purpose of clarity to be brought in this regard, we hasten to add that the moment the document is marked exhibit, without any objection, or the objections being dispensed with, it is not open to either of the parties to raise an objection at a later stage of the proceeding, nor such point can be agitated before the appellate court. Neither the mode of proof nor the manner in which it is required to be proved, nor the existence of such document can be assailed at a later stage unless the party raised objection at the threshold of its being tendered for receiving in evidence. The moment a document which is objected to and the document which is marked exhibit without objection are pitted against each other, the safest course is to accept the document admitted by both the parties, unless the court finds a strong reasons to disbelieve the same. We thus do not find such point sustainable in the instant appeal, nor involves a substantial question of law. Next paragraph. Apart from the same, the parties are governed by Daibhaga school of Hindu law. And even school of Hindu law, even before the codification of the Hindu law in 1955, the person governed by the Daibhaga school of Hindu law, if died intestate, his estate would devolve upon his sons and the daughters in equal share, which is distinct from the Mithakra school of Hindu law. Stop. The right of a female heir is recognized under the Daibhaga school of Hindu law even before the codification of the Hindu law. And therefore, we do not find any justification in the stand of the plaintiff appellant that the female heirs are debarred from inheriting the estate of a male Hindu dying intestate before the promulgation, before the codification of the Hindu law. Full stop. Furthermore, this is not a case where she has not claimed for partition. From whatever angle we look at, the instant second appeal does not involve the substantial question of law and is therefore dismissed under Order 41, Rule 11 of the Code.
The principal issue has not been cropped up, which my lord has pointed out. Whether it is a mock fight. Actually, we are fighting for the death certificate. We are principal issue.
Absolutely. This is the main principles.
Yeah, don't have any.
নয় 10 আছে 9-10 টোকেন নয় 10 টোকেন
Yes.
11 I have.
Yes.
11, you are the hard only when I could not access that.
Oh, yes.
Yeah.
11. Yes.
When I heard that what your loss is mine, then matter will be driven back to dispose of the injunction application. Now here, my client sold the property 9:30, 9:30, the two plot to Mr. Ray's client. I know. Okay, he's very much interested. But the injunction application, your losses, kindly see the what's the prayer in their injunction application. Kindly, for a moment.
Sir, we are concerned with Order 39 Rule 4.
yes.
If you say, tell me whether any case is made out by you which comes within the folds of Order 39 Rule 4. Tell us. Show us from one averment in your application that it comes within the folds of Order 39 Rule 4.
I have seen, my lord.
Tell us.
I have
First
seen
proviso, first condition is that a person has knowingly made a false and misleading statement. tell us that where he has made a false and misleading statement. Second, by judicial catena of judgment says suppression of the material facts. Where you have said that he has suppressed some fact, and this fact is very important.
But only when I am drawing on the fact, kindly see. Page 34, that they are prior. And what the identity one has been passed. Kindly see. They cannot.
Court can mold the relief. Court can pass an appropriate order. There is no difficulty.
But I am reading that portion. That identity order he paid for. He paid for. It is therefore paid.
Then go and give a objection to order 39 rule 1 and 2 application, and then say that what order cannot be done.
Yes, restrained.
Not yet disposed.
And so far 930 and 931, I have nothing to say. Mr. Rai's client, I have sold.
No, you have joined, sir.
I have joined 2, 3, and 4.
3, 4,
5.
5.
2, 3, 4. But 2, 3, 4 were sold that property is
That
gifted
is
by
your
the father.
statement, sir. This is your statement.
yes.
When you made a joint application, that
I made
means
it
every statement is yours.
Yes.
You can't detract therefrom. You have to accept it. Tell us.
But my submission before
You don't know
No,
law.
no, you also know.
What is
No.
the law?
But what I am submitting, I have heard already from Mr. I also. But your lawsuit to shorten the period, can it dispose of that application, and so far as my lord, that
We will reimpose the injunction. You can go file. We can say this order 39 rule 4 may be treated as an objection to order 39 rule 1 and 2. If they want to, they have filed their objection to order 39 rule 4, they will be, that will be treated as a reply injunction application to be decided.
if you file it is supplementary written objection, that can be that permission will get. That
What supplementary?
Some more facts.
And all have to do jointly.
Yes. 2 to
5.
5 to 5.
All have to do.
We have also filed a separate written objection. We have also filed.
No.
Yes, sir. Yes, sir.
Sir, order 39 rule 4 we have seen.
But I think if I am not wrong, but can you see?
Please show him that page where order 39 rule 4
page-
application is there.
Page 43.
Read.
Page 43.
Application by defendant number 2, 3, 4, 5.
2, 3, 4, 5. Written objection 2, 3, and 4, page 43.
That is an injunction.
Injunction.
That is
Injunction.
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 I am not talking about. I am talking about vacating, which is
Oh,
the subject
yes,
matter.
that is along with 2, 3, and 4, 5. That I.
So,
And in this application, they are plain. They paid for appointment of receiver also. That appointment of receiver, we have no objection. The entire agriculture and port that is in possession of my Renaissance client, he is already using all the facts of that property. We are not being able to enter the property also, only because of this injunction.
concede
That
the
I have heard
prayer.
from my client also. That is the situation.
Concede the prayer. He has asked for receiver. Concede it.
He has asked for receiver.
Receiver কোথায়?
In the plane, yeah, that is a prayer.
Plain-
Receiver
plain
also.
there is a-
I have seen.
No separate application.
No, he has not filed any separate application. In the main plan or the receiver that
Order 40 rule 1 application.
order 40 rule you have not but cleverly you have not filed. You know, if your receiver is abandoned, that his kind will face the consequence.
Do whatever you want to do if you are so sanguine. Order 40 rule 1 does not indicate who can file the application.
Anybody can file. I have advised my client, you file an application. Order 40 rule 1.
Do whatever, it's your, you have to take a decision, sir. The bench cannot advise you what to do, what not to do. You take your
No,
decision.
if they can be treated that that
But the written objection,
is main injunction
the written objection is already there.
Yes.
So we are not saying that it's converted. You have filed your written objection. 5 has filed separate written objection.
1.
He's appealing for 1.
Where is the 5?
5,
He
Mr.
was there, Mr. Has he also filed a written objection separately?
I have filed, page 43. No.
Mr. That is a respondent number 5. I am asking about respondent number 5.
Oh, respondent number
Has
5.
he also filed separately?
No, page 63. No. He has not filed separate.
I have not.
Along with Page 62.
It is all about vacating. I'm challenging vacating application. Separate
2,
file
3, 4.
করেছিল?
No,
আপনি
never.
জানেন না?
I don't know whether
Right now, that I can say.
5 has filed separate application.
The
5
file, but if the Lanet court will give them a further opportunity and dispose of.
Now, order 7 rule 11 is also there.
Yes,
that
they
is,
are
now he
rejected.
says that has to be rejected. I do
File
not know.
revision, rejected. In the meantime, this proceeding are going on. Now it is on the peremptory hearing board, fixed without disposing of order 39 will run. Still pending.
And his main prayer order pass an order temporary against the defendant so that they cannot change the nature and character of the suit power or cannot create any third party interest. That is their only prayer. Page 34.
True, and the order of injunction is in this form.
This one.
Order of
Also
injunction
in-
is also passed in this way.
That will suffice. Man.
Order.
Yes.
Different
From-
for 2 to 7.
From evicting the plaintiff.
This one.
From Bangla 930 and 531.
Correct.
It is cited that is in position of completely in position of defendant of 5.
Where is the document?
Part of no document.
That is I have
Where is the document, sir?
document. Well, record or right now relying on the record or right. Record of does not create a
No, presumptive value of possession.
only my law close they just suppose that only for collection of revenue.
No,
Is that
sir.
the value?
No, sir. That is in case where title is sought
Yes.
on the basis of entry in the record of it.
Record.
Where it says, no, it does not create a title, nor it takes away the title. It is only for the purpose of land revenue and making a person responsible. But there are another way of looking at it, that the entry in the record of right has a presumptive value on possession, unless rebutted.
Unless they, yeah.
So, what more?
And also some other all other procedure 2089 such and such.
But this is not
Without-
required because it is a composite suit for declaration that the deed of gift is bad. So in that event, you are the person who is a necessary party and the person to whom you have sold is a necessary party. Court can reject the prayer for partition. There is no difficulty.
But so far as the court can mold the pair, originally injunction application not to get third party interest. Only that portion. And kindly see the page 34. Main injunction application. What are 30?
Mr. Bhattacharya, you are trying to play. Very difficult, sir. Very difficult. Shoot well. He says that amend the injunction not to create a third party.
No. But cannot change that my client will be benefited. So many agricultural land and pond also. They cannot change the nature. They cannot sell also. If that pair is allowed, they will face the penalty. Because I have heard from my client. His client is trying to sell the property.
How can he sell without the deed of gift having been declared void?
Deed of gift only two block 930 931.
True. And the
Other
others,
process only
still he has claimed that he has a share in this. He does not claim an exclusive right.
No, not.
That's why he asked for a partition that he has 1/4 share.
yes.
So he can't sell. He can sell his 1/5 share. If it is agricultural land, you know the right.
If he can sell it 1/5 share, I know.
No,
But if he
they
sell,
can
if
sell,
he
no,
sell
can't
the
they
entire property,
He's
If the
how
third
can
party
he? His
is created-
case is that he is the 1/5 shareholder. His claim in the suit is that he is a 1/5
But-
shareholder.
by suppressing the fact,
What suppression? You have
No,
not.
I'm not
disclosed.
saying that. I'm not saying that. Yes, not to the purchaser. Whereas I'm the owner, only owner. This is the order. He can sell it.
No,
That is the
no
reason.
such allegation in either in the pleading.
My client is not
You
able to.
you are building a case or making out a case for your client sitting there without your client having disclosed all those facts in the application. Can a case be made out by a counsel when his client has not made out such case?
But what's the identity model? Resident for evicting the plaintiff. That means he is in possession of the entire property. Evicting the plaintiff.
Sir, his position is not only in commensurate with his share, but on behalf of other co-sharers. If the other co-sharers come forward and say, yes, partition it, he is agreeable to partition.
Jointly position on behalf of.
You cannot, because the 3 of the properties went to you. as an exclusive owner and you have already sold it. Who is to be
Other
believed?
properties in possession, the house property, there are 2 rooms, that is in my possession.
Sir, I do not know.
Ancestral.
Where is the document?
Document is, he has not added
Nothing.
document. Then but that liberty may be given, but to get this
Oh,
document,
fine.
if some facts are necessary, we can add this.
Tell us what are the facts which are necessary.
And then here, then I can find there is no.
No, tell us the facts so that we can see that what you are saying, you should bring it.
I can bring Mr. Rai also. I know Mr. Rai's client is 930 and 31. He's in possession. Then I can ask Mr. Rai. The 2 plot, big plot that is in possession Mr. Rai's client. We have sold. I know. That is Mr. Rai's position.
He has not been able to sell as of now. You have sold it. Then who is to be believed more?
Actually, by way of gift, that has been gifted to me.
Now that is a subject matter of challenge. He may lose.
But if I know the suit,
he may lose. He may.
But there's no order. There was nothing, no suit. That is why you have been gifted. We become the owner.
We are not making any comment thereupon. We are simply going by the provisions of Order 39.4, nothing more than that. That's all. Ex parte ad interim order of injunction granted by the court on 14/2/2022 in a suit for declaration of the deeds of gift to be void with the consequent relief of partition is stood recalled and not set aside by the impugned order. While disposing of an application under Order 39, Rule 4 of the Codice Procedure, filed by the respondent number 225. The plaintiff proceeds with the assertion that originally the properties included in Schedule A to the plaintiff belonged to one Taraknath Singho Roy. Who during his lifetime married twice. The appellant and the respondent number 1.
After death of first marriage, second.
Are they?
Oh, sorry. I'm sorry. But I
I never said that married twice, even during the subsistence of one, he married twice. Let us proceed.
Oh, yes. I'm sorry. I saw that. But I have heard it. Yeah.
The appellant and the respondent number 1 are the issues from the first wife. And the respondent number 2 is the second wife. And respondent number 3 and 4 are the daughters from the said second wife. It is not in dispute that the said owner married the respondent number 1 after the death of the first wife. And the children from the second wife are also arraigned as party in the said suit. It is averred averred in the plaint that taking advantage of the illness of the said owner, the respondent number 1 managed to procure the deed of gifts in her name, in her name, in her name and in the name of the respondent number 3 and 4. The aforesaid properties are described in Schedule B and C to the plaint, which is undeniably the part of the Schedule A property. The deed of gift is sought to be impeached on the ground, on the plea of undue influence, and that the said owner was not mentally and physically capable of taking a decision. Stop. The court, while passing an ex parte ad interim order of injunction, directed the respondents numbers 2 to 7 from evicting the plaintiff appellant from DAG number 930 and 931 of Hatua Mauja and plot number 2089, 2156 oblique 3245, 251 oblique 3220, 252, 2895 of Mauja Rajhat without following the due process of law. After the service under Order 39 Rule 3, an application under Order 39 Rule 4 came to be filed by the respondent number 2 to 5 jointly. Stop. It is disclosed in the said application that on the basis of the deed of gift, the property, the set respondent number 2 transferred the same in favor of the respondent number 5 and put her in possession of those properties. Next one. What appears from the respective stands that the position in respect of the aforementioned properties is disputed but in support of the aforesaid contention, no documentary evidence was filed by the contesting by the said respondent number 2 to 5. Be that as it may, we do not delve to go into such aspects for the simple reason that the trial court decided an application under Order 39 Rule 4 of the court in isolation to an application for temporary injunction. And therefore, the first and foremost point which arises in the instant appeal is whether any case contemplated under Order 39 Rule 4 of the Code of Procedure has been made out by the said respondents. As indicated above, the said application does not reveal any averments relating to suppression of material fact, making the statement knowingly, making a statement which is false or making a misleading statement. But solely on the ground that the position as claimed by the plaintiff is with the said respondents. It is opposite to quote the provisions contained under Order 39, Rule 4 of the Code of Civil Procedure, which runs thus. From the meaningful reading of the aforesaid provision, it is manifestly clear that it is manifest that the court, after passing an ex parte ad interim order of injunction, is conferred with the power to discharge, vary, or set aside the said order on an application made by a person dissatisfied with such order. The said provision contained two proviso. The first proviso, in our opinion, clinches an issue in the instant appeal, as the order passed ex parte is sought to be varied and or set aside. Full stop. The proviso makes the position more clear that the court can discharge, vary, and or set aside the order, provided it is disclosed that the party in whose favor the ex parte ad interim order of injunction is passed, knowingly made a false or misleading statement in relation to a material particular. It admits no ambiguity that the aforesaid provision can further be activated in the event the court finds that the ex parte ad interim order of injunction is secured by suppressing the material facts and on disclosure thereof, suppressing the material facts, full stop. It is a trite law that exercise of jurisdiction or the power by the court must emanate from the respective provisions of the statute as the authority of the court derives therefrom, and therefore cannot be transgressed from its boundaries. The moment the particular incidents are given in this in the provision, the exercise of power appears to have been restricted within such ambit, and therefore it is a duty of the court to see whether the ingredients of the aforesaid provision has been fully disclosed and or revealed by a person approaching the court. We do not find any averments in the application under Order 39 Rule 4 relating to making a false and misleading statement, nor we find any allegation as to suppression of the material facts in securing the said ex parte ad interim order of injunction. The court has to exercise the court exercises jurisdiction and the powers within the four corners of the statutory provisions, and must also return its finding while dealing a case covered under the particular provision of the statute in tune with the spirit and the soul of the said provision. The transgression from the boundaries of the said provision cannot be appreciated unless the court finds a situation where the inherent power enshrined under section 151 of the court is required to be activated. The entire order, the contents of the entire order projected an impression before in us that the trial court have proceeded to decide the matter on merit, despite the fact that an application for temporary injunction is still pending. Which empowers the court to decide the matter on the basis of the respective pleadings of the parties. We thus do not find that the ingredients required under Order 39 Rule 4 has been addressed of the court, has been addressed by the court, nor any case of such nature is made out by the said respondent number 225, and therefore the decision of the trial court cannot be sustained. We have given to understand that the order impugned is thus set aside. We have been given to understand that the objection to an application for temporary injunction has already been filed by the respondent number 224. And therefore, there is no impediment on the part of the court to dispose of the said application for temporary injunction. Since the respondent number 5 derived right title and interest through the respondent numbers 224, He cannot take any defense, dehorse the defense of the aforesaid respondents. And therefore, we feel that the disposal of the said application for temporary injunction should not wait for filing his defense. Though we were not inclined to give any further opportunity to the said respondent number 5, but we feel that since he is appearing and contesting the proceedings, he should be given such opportunity to file an affidavit in opposition, to file the written objection to application for temporary injunction, which shall be filed within 1 week from date. The appellants are directed to file what is called reply.
No,
Has been filed.
Rejoinder or reply, whatever.
rejoinder, I
Rejoinder is in a more arbitration. In the trial court, what word? Reply.
Reply.
Is directed to file reply to the written objection
ठीक है, आपने
within a week from date, so far as the respondent number 2 to 4 are concerned, and shall further file the reply within 3 days therefrom, within 3 days after receiving the copy of the written objection filed by the respondent number 5, within the time stipulated hereinafter. The trial court is requested to prepone the date for hearing of the application for temporary injunction, which shall not exceed beyond 15 days from date, and endeavor shall be made to dispose of the said application within fortnight therefrom, after giving opportunity of hearing to the contesting parties in accordance with law. The appeal and applications are disposed.
No, in the meantime, the in ad interim injunction passed already.
You will not say anything.
Not taken. Should not be taken. But they are actually they are trying to dispose, taking advantage. Time to time they are trying to dispose, making nuisance. We have
No, we are now. You are in possession.
you are trying to dispose.
You are trying. You are in possession.
কে পজিশন
তোমার মুখে ঢুকিয়ে দিচ্ছে না।
তাই তো বলছি সেই জন্য
তোমার মুখে ঢুকিয়ে দিচ্ছে না।
স্টেপ হচ্ছে তো
কে দিচ্ছে বলছে?
আপনার
এটা ভুলে গেলে করে আছে। ওদের মধ্যে
হাতে
ওদের মধ্যে
আসতেই তো
যেটা বলে ওই এক ওইটা পড়তে হবে সার্ভার থেকে বদল সার্ভার কপি আপনারা নেবে না, ওরা বলে সার্টিফিকেট কপি, মুশকিল পড়ে যাবে। মানে লার্নের ট্রায়াল জাজ মানে ট্রায়াল act on the basis of server copy. Otherwise, in every cases I have seen, no,
Give us one instance. I have already delivered a judgment on this.
I know one inspector
singly.
in one matter for the certificate copy. Not certificate copy. Net copy.
You please give me that. Please record the order. Give it to us.
Yes.
We'll see to it. is called. Huh? Continue.
I beg to appear for the respondent. Why you beg? All the time I appear for the respondent, my lord.
You have nothing. Second appeal of affirmative.
Second appeal, judgment of affirmance.
Take your seat. Do not open your mouth. Otherwise, you know the consequences.
I know.
You want to open?
Not open my mouth. May I just indicate one thing, my lord? My lord, I am the landlord, my lord. I am a 4th-stage cancer patient. Difficulty is this, my lord. Time and again they are seeking adjournment. But kindly seize the record. Kindly seize the record, and my lord, this is the document. Nothing more than this.
Milord, Advocate Anil Kumar Chattopadhyay got eye surgery and he has still some issue for conversation. So only 1 week adjournment. Mr. Anil Kumar Chattopadhyay got eye surgery and he is still facing some issues in conversation. So only 1 week adjournment, Milord.
Yeah, I see.
Two-
That's two eyes. Because 4 months before he has eye surgery. 1 month before he has eye surgery. Now this time again he has a eye surgery. That's why I asked how many eyes he has.
Last,
Two have already been operated.
Milord, last week he has got eye surgery.
1 month before also, he told us in the court that my operation is tomorrow. I am going to be operated second eyes. So we granted the adjournment.
All medical papers.
Lord Shiva has come to the third eye.
All medical papers he has, Milord. All medical surgery papers already he has. Not today.
Give it to us.
We shall produce next.
There is no stay. There is no stay. It is going on. Execution is going. We are directing the execution to be expedited. Let him take the adjournments.
But there was an earlier direction that there is no operation of stay, my lord, that we have shown before the learned trial, learned executing court. But still, despite this pregnancy, my lord, they are.
We are saying
Yes.
an accommodation is sought on behalf of Mr. Chattopadhyay that he is going to be operated to the respondent submit that since last many months the adjournments are sought on one pretext or another, including the surgery in the eyes and taking advantage thereof, the appellant is protracting the execution proceeding as the executing court is not proceeding with the since the ground of illness has been imposed, it has been we find from the record several adjournments was sought on the medical ground. Taking a humanitarian approach, we cannot disbelieve the statement made at the bar. But equally, we wanted to bring a balance between the rights of the parties. How many times? He wants a 1 month time.
Milord.
1 month?
15 days, Milord.
15 days. as prayed for, let this matter be listed after fortnight. However, pendency of the instant matter shall not preclude the executing court in proceeding with the matter. And endeavor shall be shown to dispose of the same as expeditiously as possible, preferably within a month from the date of the completion.
Great.
Here for the KVA.
We are waiting for it. Yes.
18 appear for the caveator. First miscellaneous appeal. Mr. Hon'ble is for the appellant. So kindly keeps it on Wednesday because. Great.
Oh, Mr. Hon'ble is otherwise.
But he is in difficulty Tuesday also. It will be on Wednesday.
Just simply adjourn for a week. Spill over to the next Thursday.
Yes. Great.
Wait, please, Your Lordship. This is my appeal. Suit against a dead person. I am not a plaintiff. I am not the defendant. Suit was filed against a dead person who died in the year 1987. 2017, he filed the suit. Me, I don't know who I am. I was made, I was not even a party in the suit. All of a sudden, I have been made a party in the appeal. And the first appellate court makes me a party.
You are the appellant? Or
Yes. I am the respondent in the first appeal.
Please for the other side.
She was appearing, they were appeared.
Rita Patro.
Yes. Yes, they appeared.
Pushpita Das.
Appeared, several times appeared. What the first appellate court did is remanded the matter back.
You are the heir of the deceased.
Nothing to do with him. There's a report by the process server. This person said something. He died back in 88. Suit is filed in 2017 against a dead person. Page 17 of my application.
What is your relation with the dead person?
Nothing. I am no one. I am the masjid. We are the masjid. Kangsha Masjid Samiti. And he has filed the suit against one Syed Abdul. Remand. Suit was dismissed on 3 grounds. It's a Waqaf property. Suit is against a dead person. So the suit is a nullity. Now, one of the findings, in spite of there being the process server report, the first appellate court made a finding that how did the learned trial court come to a finding that the suit was against a dead person?
So that you can hear,
My lord, several times they took time and now I'm suffering because what's happening? They have somehow, the police are coming and harassing me that this.
if we simply admit, then you know what is the consequence. We really want to make good law at this stage, if you can bring the others. It's only to just shorten the.
Yes, yes.
nothing more than that.
I understand what is coming from your lordship. It
That's
is.
why you bring them.
I'll do one thing. My lord will pass an order, just so we can inform them.
On behalf of the respondent, the appellant is directed to further notice upon the counsel for the respondent that this matter will be listed on next Tuesday, and next Monday.
No.
Or Wednesday, next Wednesday, and order what you.
My lord, 4th April. 4th April, yes.
Third is the Wednesday. You have problem on fourth.
I think I have a yes. I have a problem. Let it be next week.
I have a problem.
April Fool's Day.
Come on, third. So segment. Come on, third. For the next.
Third.
Third. You have a matter on fourth. For the next.
Appellate petitioner. My lord, suit for declaration, injunction, and my lord, recovery of cash position. My lord, in that suit, my
For prevention
and recovery of cash position. And my lord, in that suit, my lord, the appellant took out an application under order 39 rule 1 and 2. So that has been rejected, my lord. Against that, my lord, this appeal has been preferred. And the previous occasion, my lord, the section point application has been, my lord, allowed.
Injunction.
My lord.
Injunction on, you are the plaintiff.
Yes, my lord.
Injunction was called, given on the, rejected.
My lord, rejected, my lord.
Injunction is rejected.
My lord.
What is the stage of the suit?
My lord, suit is, my lord.
What is the stage of the suit?
Framing of issue.
Has been framed?
Not yet, my lord. Not yet.
Not yet.
Not, my lord. My lord, the court holds that, my lord. My lord, the impugned order, my lord. Kindly see, my lord. The plaintiff's averment, my lord. Page. Internal page 3, my lord. Learned lawyer of the plaintiff submitted, my lord, the facts of the case, my lord. The my lord, one scheduled property was originally belonged, my lord, one Abdul Hafiz Molli. And my lord, he, my lord, gifted the property his wife in the, my lord, 8th April 1993. And thereafter, her name was, my lord, Arjuna Bibi. And my lord, she also gifted on 28th March 2000 to her daughter. Registered, my lord, gifted, my lord. And the daughter, Ajima Khatun, thereafter, my lord, sold the property 8 decimal VT land, my lord, to the plaintiff in the year, my lord, 22nd May 2012. And thereafter, my lord,
Sold the property to whom?
The plaintiff, my lord.
Plaintiff. Say that.
Plaintiff, my lord. And my lord, thereafter, the defendant, my lord, creating, my lord, several disturbance in my position, my lord. Therefore, I filed this suit, my lord. And my lord, subsequently, they appeared in the suit and they disclosed that, my lord, they said, my lord, original owner, Abdul Hafiz Malik, after giving the, my lord, give deed to her wife, my lord, the same property, she thereafter gifted her son.
Abdul Hafiz
Gifted the property
to her wife, to
wife,
his
my lord,
wife,
1993.
to his wife.
Yes.
That is, you are also admitting.
Yes, my lord.
Now they say that the wife.
No, not wife, my lord. The Abdul Hafiz.
Abdul Hafiz then sold it.
Gifted his son in 1995. Subsequently, same property, my lord.
Same property.
Same property, my lord. My lord, the court, my lord, held that, my lord, kindly internal page 3 of the impugned judgment, my lord. The learned lawyer of the plaintiff submitted before me that procedural suit property belonged to one Abdul Hafiz Malik and Abdul Sattar Malik in the ratio of 8.
Very simple question.
My lord.
Very simple question.
My lord.
If a person has divested his right title and interest, can he divest his right title and interest? That's the only question. Can he do it? Now, you have to show that the first deed of gift of 1993 in favor of his wife, Abdul Hafiz, in favor of his wife. Show us that what is the property which is described. You said same property.
My lord. My lord, court also,
why the court has refused to accept this?
My lord, court has, my lord,
Why? What is the finding?
only not properly described the property. Only. My lord, kindly see the
where is the
page
finding?
9. My lord, internal page 9 of the impugned judgment, my lord.
Yes.
I am, second line, my lord. I am of opinion that the suit property is required to be protected from being damaged or act of mischief and was, but the description of the suit property as given by the plaintiff with regard to co-1 suit property is rather vague, mismatch with the pleadings. It is also evident that plaintiff by way of amendment had inserted the fact and defendant number 1 had during pendency of the suit had raised boundary wall covering the entire co-1 schedule property and made 2 brick-built asbestos set room and 1 asbestos set veranda in the northern portion of the co-schedule suit property. And my lord, court also held that, my lord, the previous page, my lord, page 8, my lord. My lord, page, third paragraph, my lord. Both the deeds Hevanama,
where?
Page 8, previous page, my lord.
No, he has held that yes, this property is to be protected.
My lord.
But then he said that because of the vagueness, he can't. So where is the schedule co-1?
My lord, I have, my lord, submitted all the documents. Page 5, I have documents, my lord.
He wanted that.
My lord, they are trying to, my lord, change the nature and character of the suit property, my lord.
You have not described button and bounded. That's why it says that vague and.
My lord, I have, my lord, submitted the documents, my lord. Page 5. Kindly see. CS record, RS record, give deed, subsequent give deed, as well sell deed also. Certificate, my lord, issued by Panchayat authority who allow me to construct, my lord, building.
My lord, page 5.
You ask for recovery of possession.
My lord, recovery of possession, my lord. My lord, my lord, my lord, court held that, my lord, both the parties claiming the title, my lord, of the same property, my lord. And there is a tribal issue also, my lord. So, my lord, defendant are trying to, my lord, change the nature and character of the suit property, my lord. They should be injuncted, my lord, not to transfer, not to create any third party interest, and also not to change the nature and character of the suit property till the disposal of the suit, my lord.
What? What do you say? What do you have said?
My lord, court held that, my lord, the suit property, my lord, should be, my lord, protected. My lord, the defendant, they are trying to, my lord, change the nature and character of the suit property, my lord.
They're trying to.
They have
already changed the nature and character.
And
They have
if,
already
my lord,
changed the
they
nature and character.
and also, and my lord, if they, my lord, transfer the suit property, my lord, my lord, there are serious tribal issues also, my lord, involved, which need to be, my lord, determined.
Boundaries or numbers in the systematic version. The numbers or numbers in this record of the settlement or settlement. Sufficient to identify. Rates and specifies and so on. Boundaries or numbers. So what he's doing is that like all the recent possible BT revenue points 08 acres of land, not number of processes. Numbers is plot number 66. And Khatiyar number is also given. And PS Chanditana district. This was a lot. Technical. Requirements. Contain Bharati. Yes. Showing the location of This is every part of it. Yes.
My lord, in page 8, my lord, the observation of the learned court below.
Let us hear him. Yes, sir. Your claim is from 1995 deed of gift.
I bring the Lordship, kindly go to the page 8 and 9 of the document.
Yes.
However, that's part. It is for
Yes.
the party to prove.
Page 8.
8 and 9.
You are reading from where?
Page 8.
Page 8.
Middle portion.
Middle portion.
Middle portion.
Second paragraph.
However,
Just let us find out.
from the 1, 2, 3.
However.
However.
Where? However.
However.
Yes, it is for the party. Yes.
Whether the deed of Benama was acted upon by the respective vendor or not. And such issue can only be proved by adducing evidence at the time of trial. While disposing the application for temporary injunction, petition of this court shall only take recourse of the base value of the document. It's appeared to me that prima facie there is no document of the plaintiff to show that both the vendors of the plaintiff, the report has been but vendor who has the position in the suit property. Plaintiff's vendor to remove both were not in position of the suit properties. On the contrary, the defendant number 1, it appears to me the vendor of defendant was in position of suit property for party with the in favor. Though the plaintiff was recorded in the party. Therefore, questions to the plaintiff was in position before the disposition in the matter of trial. But I also agree with the defense counsel that there is no mention of date of disposition by the plaintiff.
Sir, there is no difficulty. Once he has prayed for recovery of possession from you, please consider. Once he has prayed for recovery of possession from you, that itself is a proof that he is not in possession.
Yes.
He is not in possession. He asked the possession from you. What he says he has gone by this. You are in possession. Now question is, you are claiming title from a deed of 1995. They are claiming title from a deed of 1993. Both the deeds, 1993 and 95, was executed by the common person. Now, question would be first, whether the prior deed would prevail over the latter deed in respect of the sale property. The answer is in unequivocal term is that prior will prevail. Now, second point you said that the prior deed was not acted upon.
Yes.
It's a matter of evidence. It's a matter of evidence, but prima facie at this stage, because the onus is on you to prove it was not acted upon.
Yes.
So, at this stage, on the face value of both the documents, at least he stands on a higher pedestal. So you are in possession, be in possession, do not make any constructions, do not alienate the property to a third party.
Second point, bro. This is the first point. On which point?
That is the main point.
No. That is which point the court below has rejected. Rejected on the basis that the schedule is not clear.
Correct. Order 7, Rule 4, we have seen. Is there any penal consequences provided under Order 7, Rule 11? It says not only by boundaries, but numbers. If he has given a plot number, the dark number such and such, plot number such and such, what does it mean? Is it a mandate that he should give a boundary butted and bounded by the north, south, east or west? From where you get it? Look at Order 7, Rule 4. Tell us.
I'm not.
You read.
But
I do not find
there is-
anything from there.
There are two
So-
schedules. There are two schedules there.
Sorry.
Total schedule
He
and
talks about one is the
one.
larger one, another is a part of that larger one. Core one. He is concerned with the core one.
What is fitted with which part of the total?
What?
The smaller part is fitted with what part of the total?
Maybe that is his. When the survey pass commissioner will be appointed, you will take care of that.
My lord, total area covered baranda. My lord, covered the my lord wall. Total area 8 decibel.
That is what is there. You have said, amended the plaint, says that the
My lord.
entire.
Give liberty, my lord. My lord, give.
And you are claiming that what sufficiency one can have.
Yes, yes, amended claims 11A.
Sir,
It is not stated anywhere.
the undisputed fact is, both of you are claiming the right in respect of Core 1. So far as the property Core 1 is concerned, there is no dispute. You said that I am occupying this property, which is a Core 1. He says this Core 1 belongs to me.
He is not possession because of the from the.
But he is not possession. Who says he is in possession? He has asked for recovery from you on the strength of his title. So property is not in dispute.
Question of title.
The ambiguity is not there.
Question of
You are the
title.
person.
The question of title. The question of title. That has to be proved. So,
Proved at the injunction stage.
Yes. That
How?
by child. Because you as stated that your lordship maybe now.
It is not. It is whether the first deed, 1993 deed was acted upon or not acted upon is a matter of trial.
Yes, Lord. I'm very big in my mistake.
But at this stage, if you sell out the property to a third party, then
Oh, why is it? I have already built a new building.
I'm asking you. I'm asking you. If you sell out the property, then what? If he ultimately succeeds in establishing his title in the trial, what will happen? What will happen? You can't predict that everything will go in your favor. It may go against you also. It's a matter of trial, what the evidence would come. So till that time, some protection has to be given. Do not transfer it to a third party. You have already constructed. Be happy with your construction. Do not make any further construction.
Yes. That can be.
And not
That
to,
is what
not
you
to
want.
transfer and alienate.
I am not going
And not to
transfer.
create any third party interest.
I have decided with my sons.
My learned.
Happy, reside there until evicted.
Now
Decide.
What I am I am submitting to lordship, both of lordship. Let them get direction for to.
We are expediting. Don't
Expedite-
worry. We will expedite,
Expedite the
but
matter.
protection has to be given.
Expedite the matter. It is short period. Yeah. Lordship is good. If your lordship says also they will undertaking also.
Yes, we are recording.
Yes.
Don't worry.
And my lord,
And no
my lord
difficulty.
also
When he is
give the my lord, give
giving
liberty,
no,
my lord, give liberty to amend the my lord plate, my lord. Give liberty.
no, that is up to you. Why we will?
My lord, one judgment, my lord.
No judgment. But you take care of that.
I am giving it until your document recording. But at the same time, I am order praying not to disturb my position in the meantime by the plaintiff. By the plaintiff, we are creating disturbance. This is your neighbor.
File an application for injunction.
Prolonged litigation. You will also write a one line. You also not to. Since I am giving it undertaking, I am giving undertaking.
You have been able to construct such a big house and living with your son. Do you think that he is capable enough to create obstruction? He could not succeed while you started the construction and completed it.
When I was started, he is being a neighbor, never objected for several years. When I constructed fully, then he started the case.
The dispute involved in the instant matter pertains to a rival claim of title in respect of a sale property. So, both the parties claimed their right title and interest on the strength of deed of Hibanama executed by the admitted owner. Deed of Hebanama, 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 executed by the admitted owner in a close proximity of time. A plea is taken by the respondent that the Hibanama executed in favor of the appellant was never acted upon. Obviously, it is a matter to be decided upon full-fledged trial. So, the injunction applications are decided on the basis of the affidavit evidence, and any finding returned thereupon is tentative in nature. It is a trite law that a person, by executing a valid document, divested his right title and interest in respect of the immovable property, cannot redivest the same in favor of the other, as the deed executed prior in time would prevail over the deed executed later on. But in the instant case, the question is of acting upon the first document, which can be decided after affording an opportunity to the parties to lead evidence. It admits no ambiguity that, apart from the relief in the form of declaration and injunction, the recovery of possession is also sought by the plaintiff appellant against the defendant respondents, which implies that the defendant respondents are in possession of the core 1 scheduled property. So it is by way of an amendment in the plaint, the plaintiff appellant incorporated the further facts that, taking advantage of the suit having pending before the court, that contesting defendants have raised the construction at common scheduled property and also secured it by raising a boundary wall. Interestingly, next paragraph, the trial court rejected the application for temporary injunction solely on the ground that the description of the property in K1 schedule is vague and ambiguous. Probably the learned judge intend to rely upon the provisions contained under Order 7, Rule 4 of the Code of Civil Procedure, which postulates that a suit relating to immovable property must be sufficiently described so as to identify it by boundaries or numbers as per the settlement or the survey. We have been taken to, not Order 7, Rule 3, not 4. We have taken to the schedules appended to the plaint, and does not find prima facie that there is any difficulty in identifying the said property. Furthermore, the contestant defendants are claiming their right title and interest in respect of Clause 1 scheduled property, and have also admittedly protected the same by raising a boundary wall. Therefore, we do not find that the vagueness or ambiguity in description of the property can be a ground to reject the application for temporary injunction. Be that as it may, the counsel for the respondent, in his fairness, submits on instruction that his client has no intention either to transfer, sale, or create a third-party interest in respect of clause scheduled property, nor shall make any construction thereupon.
Any further construction? Any further?
Construction thereupon. Stop. It is, however, clarified by the counsel for the respondent that the construction has already been made and completed in all respects, and therefore there is no necessity of passing the injunction, the order of temporary injunction. The counsel for the contesting respondent further submits that his client would give an undertaking in this regard. Full stop. In view of such a stand taken before us, and the intention being laudable that the respondents are not attempting to transfer, alienate, and or create a third-party interest in respect of covered scheduled property, nor intended to make any further construction thereupon. We thus find that the sufficient protection has already been extended to the appellant in this regard. Since the respondents have volunteered to file an undertaking, let such undertaking be filed before the trial court within a week from date. In view of the above, the appeal is disposed of. In view of the above finding, the appeal and connected applications are disposed of.
Should not be disturbed. I am taking undertaking.
We find that the suit has reached to a stage of framing issues. We therefore request the learned judge in the trial court to make efforts to bring the suit to its logical end within 4 months from the date of the communication of this order. Now happy?
Only the plaintiff should not disturb.
Let him also give an undertaking like you.
Yes.
What are you talking? Think. Can't be done.
Get rid of it.
Clause 1 schedule.